8 years back, my lord. Since then, no communication with us, my lord. So matter may be adjourned today. I will try to contact him. Phone number also not available. Maintenance case, perhaps it may be settled or something may be happen.
Otherwise, you are for the petition.
I am the petitioner. No stay order is here. And wife also not to appear in this case, I think. So after vacation,
The request
item
by
40.
Council Mr. Anuddin appearing for the petition. Paper and request that matter is that the matter be accordingly listed immediately after petition as on the petition.
I am blessed.
May it please your lordship, I beg to mention item number 4. With the consent of the other side, my lords may kindly be pleased to adjourn this matter, and my lord, can it be taken out on 11th May, my lord?
11th of May. I'm for the other side.
11th May, it's holiday. 11th of May.
May,
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 my lord.
Sorry, May. May, what is this?
Monday.
Hearing day,
Monday, your lordship.
it's a Monday.
Monday, my lord.
Uh,
4.
I'm for the informant
you are
in
for
this
the
matter.
informant.
Indeed.
Request by Council for both the petition as well as informed respondent. The matter is that the matter be accordingly listed on 11th of May, so and so. In addition. Okay, we are listing it on 11th of May.
Much obliged.
Much obliged.
May I please, your lordship, I beg to mention one criminal petition, my lord, to come up for hearing, my lord, on
Make a mention before court number 8.
court number 8.
Lordship, we beg to mention item number 1 and 2.
1 and 2. Yes.
Other party joined in the mediation process as per the honorable court order dated. So they took another date which is fixed on 24.
No, one mediation is already sitting is there or no? How many?
One
already-
they have sat, your lordship, on
Yeah.
12th March.
On
After
12th
that,
of March.
another date has been fixed on 24th April.
24th of April.
April.
Yes, your lordship.
One and 2 একেলগে কৰি দিব। You are for the
Petition.
petitioner.
Item
Mr.
number 2 is interim here. So interim order may be continued.
You are Mr. Saikia
Item number 2.
You are
Mr.
Mr.
N. Soikia. N. Soikia.
and Saikia.
Right.
In both the matters, you are appearing, your name is there.
Yes, madam.
Yes. 1 and 2 দিব heard Mr. Saikia, the learned counsel petition. Also heard Mr. A. Mishra. Your name is not here.
I'm on behalf of Mr. Esnawat, your lordship.
Appearing on behalf of Mr. S. Now submitted that in person to the order passed by this court. There was one sitting of the parties in before the mediation, and next date is fixed. The mediation is on 24th April 2026. Next review of this, let the matter be accordingly listed after mediation at itself. 7th of May.
Could it be after election, your lordship?
7th of May.
After
The result
election.
of the election.
Result when? Result is,
9th,
Well, he's-
second, third.
Petitioner is a service holder in from police department.
oh, he may be engaged there.
Yes, my lord. No, 25.
Well, sorry, our result is will be on which result
Nine.
on 4th. Okay, then result for the matter.
20.
13 will be okay.
20.
No,
20.
20th. will be
20,
okay,
my
your lordship.
20.
20.
20th. Is there any probability?
Yeah, my lord. Yes.
Probability of
Probably is
petition is there.
Yeah.
Very nice. We welcome this day. Anyway, okay, that's right.
Master please.
May I please, your lordship, I beg to mention item 24. It was AB for case diary. CD.
Be for case diary.
But probably CD is not there.
Are they on entry? Item number 24. serial
That may be fixed at
issue reminder.
May 2nd week, my lord.
Issue reminder.
And
It may
in
be
time,
continued till next date of this.
May be continued.
When in the
Lordship, in the month of May.
May
12th of May.
Lordship.
highly obliged. In time to continue, my lord.
Yes, yes. Your interim will continue.
Highly
May
obliged.
I please, your lordship, I would like to mention item 7 of the daily list. My senior went to hometown. So for election, the matter may be adjourned for the day.
The request made by the counsel for the petition, counsel appearing on behalf of Mr. S. Learned counsel for the appellant. Your appellant is behind the bar or what?
No,
Is still in jail or outside jail?
outs,
No, whether he is in jail? No.
outs, not in the jail.
Not in the jail. Oh. After vacation?
After Bihu,
Agent for the day only. Okay.
maybe it may be listed after Bihu.
I will list adjourning for the dates. Adjourn.
7, item 7.
Yes.
Oh.
Adjourn.
Lordship, I beg to mention item number 11. Perhaps the CD has not been received in this.
Yes. What is the position of 11? But they are on jail.
Interim Lordship.
Is it a charge sheeted case or not?
Lordship, it's not a solicited case.
You are in custody since when?
I am on interim, Lordship.
Oh, you are on interim. Okay, then he is on interim.
Date of forwarding is 12/2/2026.
No, otherwise also he is on interim.
He's on interim Lordship. So, first week of May, any date. also. 7 May.
City not received, issue reminder. Interim be continued, till next state of testing. List matter accordingly on 7th.
I am deeply aware.
May I please your lordship, make mention for listing writ petition criminal
Make a mention before court number 8.
8.
My pleasure, Lordship. Lordship, item number 15, Lordship. CD perhaps not received.
1-5.
Lordship, 1/5.
Yes.
Not received, it is not an interim.
Interim is.
You are on interim.
Yes.
Did not receive, issue reminder. Interim be continued till next state of testing. Okay, then 7th of May.
Lordship.
Listing it on 7th.
Obliged.
Wait, please your lordship. Lordship, I beg to mention daily list item number 27.
27.
Lordship, perhaps CD is not received.
Yes, what is it? 27? Case diary is not
Lordship,
available. Are you on interim?
Yes, lordship, I'm on.
They are on interim?
Lordship.
City not received, issue reminder. Interim be continued till next session. 1-3.
1/3.
Much obliged.
My pleasure.
May, no?
Item number 14, Manoj. Similar affair. I am on interim and case day is not available.
Yes, Lordship, this petitioner is on interim.
City not received, issue reminder. Interim be continued till next state of testing. Yes, that's 30th of May.
Not 13, my lord. Maybe before or one
Okay,
or.
then in that case, 7th of May.
Mile. 7th of. Much obliged. Interim maybe.
Yes, sure.
Lordship, I also beg to mention item number 20, your Lordship.
Yes, what is the position of scan copy we have received already?
Scan copy of PC of.
Has been received. Lordship. We have some difficulty today. Can it be taken after the?
The request made by learned counsel for the applicant, A. Mishra, matter is adjourned. Scan copy of the TCR has already been received. EST matter accordingly. We'll do 12th of May because
could
they are
just-
not interim, I think, na?
No,
Is that
Your-
considered case?
Yeah, yes, Lordship. It could
Yes.
be late.
May not be fixed, just after vacation, ma'am.
Just after vacation. Immediately after vacation as an date.
My lord, I am praying for listing on criminal petition, my lord.
You make a mention before court number 8.
Ma'am.
Very nice. Motion, we got nothing on Friday. আসলে আগৰ মোশন ইমান এডমিশন পাই দিব গৈ না হ'ব বুজি পাইছো না হয় ঠিক আছে একো নাই এই that এটা দিলে মোশন
May- 43. My lord, regular bail application, your lordship.
Yes.
FIR at phase 9, Your Lordship. Here, petitioner number 1 is the FIR name accused, my lord. But the petition number 2 is not FIR name.
He died.
He
Right.
died, man. He died. CD confirm, man.
He died. Huh? Now see, CD will be definitely after vacation will be.
Yes,
Uh,
But petitioner number 2 is not FIR name.
maybe.
what
my lord.
what will-
FIR is specific.
Yeah.
21.
When you are not needing.
44 days.
But it's that legal labor.
24.
Legal for the legal of 27.
Fine. 24th, 21, many matters are there.
So 21 may not come also, my lord, because from tomorrow,
Yes.
there are election, thereafter holidays, my lord.
Fine.
No message.
Okay, then 24th,
Man,
CD be called.
obliged.
Please, Your Lordship.
Yes.
Regular bail application, Your Lordship. In this case, the FIR and cross FIR is there. But the connected case is fixed on 21. CD may be
21,
21.
but
four.
cross FIR is.
Cross FIR is also there.
CD
No, no,
is
no.
not
Yeah.
the same.
Right.
Same-
In this
same
case,
CD, no?
same CD. Your Lordship. In connected,
saying
case-
cross
in my
FIR?
case is cross FIR is there. FIR and cross FIR there in each one. But in connected case, is similar case. Same
Similar
FIR.
case is on 21.
21. Yeah, right.
Just tell us the number,
AB 59226.
AP 592.
2026. Your Lordship, Your Lordship.
CD be called.
Penal
This
decision?
the matter accordingly on 21/4/2026, along with AB 592 of the.
May I please, Your Lordship. Regular bail application, Lordship. Charge sheet case. Scan copy of PCR may be called for. Lordship.
Is the charge sheeted 103?
103.
Scan copy of the PCR we call for registry will put in it. Yes, when it can be, it has to come from which place?
From Insukia, Lordship. 24.
Dumduma.
24.
Charge sheet. 24, Lordship.
Okay, ready.
Obliged.
Now, this is a regular bail application. This is also charge sheeted case, my lord. The case is suicidal case, my lord. 115
So what is the
days,
stage of the case at present?
lordship.
Stage, can you tell us this charge has
Case
already
is,
been
my
made?
lord, the trial has started, my lord.
Trial started.
Trial started, my lord. So, my lord, I think, my lord, there is no any requirement because, my lord, there is a whole, is also stated in the CD, my lord, I was the CD, that, my lord, 2.5 years boy is there. Or his, my lord, ailing mother is there. Only mother and he is the family member, my lord.
Who died? Why?
Wife died, my lord. So due to hanging, my lord, it is clear that there is no any medical report, no poison, nothing, and no torture. And my lord, she was also mentioned in the city the psychiatric patient. And earlier also she attempted for suicidal, my lord. So this is a, my lord, only false implication, my lord. And others family members were released, my lord. Only the husband has been detained, my lord, for more than 115 days. Lordship will find page 32. It is clear from the report that, my lord, para 14. Although it is a lengthy charge sheet. That, my lord, considering the facts they are stated in their statements that the marital collected so far indicates the death was due to suicidal hanging. And also no torture, nothing, no wound, no injury was found.
Now saying death for suicidal hanging is most probably not disputed.
No, sir.
She died for hanging only.
But no
There is
torture in the,
no
no torture,
homicidal
nothing.
death is not there, most probably suicidal death may be there.
Yeah.
But why she committed suicide, that is the main issue.
That is the main.
Related as can.
Because leaving behind 2.5-year-old child, she had to take
Yes, my lord. He is the only earning member of the family, my lord.
whatever. Now the other family members are free, no?
No, my lord,
All other family members are free.
no, my lord, they're the daughters has been married. They're the married
No, all
daughters, my lord.
other family members are free now.
They're female. Other family members
They
means the
can take the
daughters.
burden then.
Only my sisters, married sisters, my lord. They are not living with me. my
They
lord.
will be able to take the burden now. Okay, when this scan copy of the TCR along with the case diary be called for, registry will do it
Maybe immediately after vacation. my lord.
immediately to 2021. Many matters are 20. You may not expect also 20.
21 or
21.
Hmm.
23.
Lost. Sessions case number 42 of
Yes,
Sri
we'll call.
Govind.
We'll call.
Obliged.
None case.
47 is a charge sheeted case or no? Not charge.
Not charge sheeted, madam.
None appears on court petition. List the matter accordingly. Verification and then it. But since when he is in custody?
It is, minor, from 12/3.
12/3.
12/3. So,
Okay. Immediately after the case.
May it please your lordship. Lordship, this is a regular bail application, lordship, already in jail custody for 43 days, lordship. Allegation is lordship kidnapping and lordship trafficking, but the present petitioner, lordship, no doubt this victim went with the petitioner, lordship. Thereafter, she entered into a living relation with another person. The victim has already been recovered, lordship. This is the statement reflected that he has recovered, lordship. She has recovered, lordship. And living relation affidavit that lordship is in Hindi on page 22, lordship. One part they have somehow lordship procured it.
From the order, it seems that the victim already recovered.
recovered, man. But page 21 is the madam.
21.
Yes, sir. Session just order, madam. Learn it. I perused the case diary, accused persons. Madam. This petitioner is also there, madam. Arrested in such and such case, madam. Accused person FIR and materials in the case diary reveals insufficient incriminating materials against them. Moreover, the alleged offences include abduction, trafficking, which are serious in nature.
Already
After
lordship recovered, lordship 43 days, lordship
After
considering the length.
perusal of the city, madam. Recovery is okay, madam. Whether they are entitled for bail or not, that has to be decided, madam.
But her age reflected, lordship, 20 years, lordship. She is in relation, lordship.
Relation means what?
A living relation with another person at Delhi, lordship. She went with me for a search of job, lordship. There she entered with a relation with another person, lordship. Now, lordship, girl already been recovered, lordship. We will face the trial, lordship, considering the length of detention, lordship. She even refused to come to
The person
Gauhati.
with whom you have submitted the photograph, it seems to be an aged person.
Yes, lordship. His wife has died, lordship. Thereafter, there is a system, lordship. They cannot marry second time. He's from Rajasthan, lordship. Now in living relation with this girl, lordship. That is what happened, lordship, there.
Where from you have collected this one?
Lordship is supplied by the lordship petitioner, lordship.
No.
Yeah, this
Thank you.
well, lordship, I'm not on that, lordship. Since recovered here already 43 days length of detention, let him share the trial, lordship.
140.
Trafficking, 90 days of
90 days. Under section 140, 143, madam.
143 is trafficking and 143 is kidnapping. Kidnapping for ransom and yielding that may not come, lordship.
Kidnapping is
At this stage, my lord, let the CD be there, madam. It will reveal, madam.
how many days statutory?
43 days is a 90 days offense.
90 days offense, madam.
But Lordship, so far, Lordship, 140 may not apply against this petition, where say she was not kidnapped for ransom or murder, Lordship, that was not there.
No, no, trafficking. Not
Trafficking
for
part,
ransom.
trafficking part, Lordship, she has already, Lordship, recovered, Lordship.
Recover,
Yes,
Recovery is okay. I can
recovery is
understand.
okay.
Trafficking is there.
yeah, traffic.
Where from it has to?
It has to come from, Nalbari.
Not
Banglamari, no, Nalbari.
Nalbari.
20 will do, no?
20, ma'am.
20 can? No, within 20, it will may
Lordship.
reach. 20 could.
Oblige, Lordship.
Your Honor, this is a Sarsited case. Trial has already been started. SARS were framed, and he is behind the bar for 60 days. A 51-year-old person, well known in his locality as a good person, no criminal record as such till that, and he was purely falsely implicated in this case of fake currency. Some fake currency were recovered from his shop, and his neighboring shop owners and all local persons have given their statement in affidavit in favor of him. I have annexed all those documents. So, and in the search sheet itself, there was no independent witness. All the police witnesses are there, and they have till that found nothing against him, nor any. If he is a handler of a fake currencies, there must be some link to the person to whom he delivered this money, or from where he collect this money. Such no link has been found till that, and only on the basis of that fake currency, which were stated by all the neighboring person, that some two persons were came in absence of the present petitioner, who was at that time went to collect his gas cylinder, and that two person were come and kept one polythene bag, a black polythene bag, and immediately when he came back to the shop, some police persons were come and recovered that polythene bag where this fake currency were recovered. So my humble submission is that as the trial has now begun, he has ample reasons and ample evidences where he can defend his case if he has been provided a fair chance to defend his case in trial, Your Honor. So that is my submission. So Your Honor may consider this case, Your Honor.
Yes.
Lordship, may kindly come to page 27, my lord. It is not a matter of the one or two notes, my lord. It's near about, my lord, 210 numbers of suspected, my lord, fake currency, my lord, and it will amount to 1,05,000, my lord. So he might be also right, my lord. That will depend upon the, my lord, record and the trial, my lord. Prima facie, my lord, there is some materials against him, my lord, because so much of currency has been seized from him, my lord. So he has to.
Because sometimes yes, because sometimes it happens that some person may come to your shop and they may give a fake currency to you.
Hmm.
And on
And
good
that is a
faith,
different.
that is okay. But 1,05,000
1,05,000 is a
quite a
quite a huge amount. Huge amount.
It was admitted that some person were came and kept there in his
it is your
absence.
case only.
Yes, Your Honor, but except that recovery of the currency, there is nothing against him, and no criminal antecedent and no criminal record against him. He is a well-known, socially rooted person and very calm person. He is very innocent kind of person, Your Honor. Every person was, every neighboring shop owners have given the statement. What I have stated, they have given that statement in your affidavit. Your Honor may find this affidavit.
This one, this is kept pending in before which court?
Session court, Your Honor, that is
In yes, Baksa.
Baksa. Yeah.
Bucks.
And if we lordship go to the statement of the accused person, man, he also not stated anything. He only stated that some FICN are kept in my stationery shop. No other explanation, man. That he has gone there, somebody has kept there falsely, nothing, man. And they said that they brought me to Simla PS. That's enough from my side. He only wants to dispose that much.
Nothing more.
Nothing more.
I have also
Annex,
So let it.
I also annexed his bank statement, Your Honor. No transaction, nothing has been there in his bank statement the last 6 months, Your Honor. And in your Honor may see page 27.
See, he may be engaged by someone also for distributing those fake currencies to the customers and all. There may be some.
At least perusal of the record is necessary.
Yes,
my
but
that's
Your
what-
Lordship,
And also there-
my humble prayer is that based on this fact, his
the
a fair sons may be given to defenses trial.
scan copy of the TCR along with the case diary be called for, which he will do the needful. 20 23 23 24th of 23rd of April.
Your Honor, it may be 20 20.
20 we can provide you, but 20 probability. Tomorrow is the last working day for our office also, so 20 may not reach also. It may not reach by 28. Because tomorrow is the last working day. If it goes, then it's okay. Otherwise, and up to 19th is a holiday.
Yes,
At night.
So 20 may not be there. Chances is
20
very-
or
23rd. That's
23rd.
Okay.
Of like-
May I please? So this is my regular bail application. 50. So this is my very common incident my lord, during election time, my lord. What is my lord, two my lord, political campaigning group lordship. There is my lord, some situation created my lord, situation my lord, out of which my lord, the petitioner is arrested my lord. My lord, page number 15 is the my lord FIR. There are altogether my lord 6 accused petitioner in name in the FIR my lord, including the petitioner. To my knowledge my lord, out of 6 my lord, petitioner arrested, and the remaining 5% my lord granted bail my lord by the police my lord. Page
why
number 15.
you are the very unfortunate person.
But very unfortunate person, my lord. That is why my lord today. This is a common incident lordship in the during election time, my lord. Kindly copy of my lord, page number 15, this is a FIR. May I read, lord? সন্মানপূৰ্বক সহকাৰে আপোনাক জনাও যে আজি ইন 29/3/2026 তাৰিখে দেওবাৰে প্ৰায় 1 মান বজাত 80 নম্বৰ জোনাই বিধানসভা সমষ্টি কংগ্ৰেছ দলৰ মনোনয়ন প্ৰাৰ্থী শ্ৰী ৰাজীৱ কুমাৰ মেধকদেৱে চিলাপথাৰ থানাৰ অন্তৰ্গত নামনি চিচি টঙানী দলীয় নিৰ্বাচনৰ বাবে দলীয় কৰ্মকৰ্তাৰ সৈতে ৰাওনা হোৱাৰ পথত কোলাজান তিনিআলিত বিজেপি দলৰ নিৰ্বাচনী কাৰ্যালয়ৰ কাষত ৰাজপথৰ চাৰিওফালে বিজেপি কৰ্মকৰ্তাই কংগ্ৰেছ প্ৰাৰ্থী ৰাজকুমাৰ মেধকৰ সৈতে PSOৰ লগত গাড়ী নম্বৰৰ বাহনৰ লগতে কেইবাখনো গাড়ী শিলগুটি আৰু লাঠিৰে মাৰি ক্ষতিগ্ৰস্ত কৰে। লগতে কংগ্ৰেছ কৰ্মী বালি নপামৰ নিবাসী সৰ্বেশ্বৰ কুটুম, অকাজান শান্তিপুৰৰ নিবাসী বেনু মেধক, 3 নম্বৰ বালিপৰা নিবাসী অঞ্চলা চৈঞ্চো চুকাৰ দা লাঠিৰে মূৰ পিঠি আৰু হাত ভৰি সকলোতে মাৰপিট কৰি বেয়াকৈ জখম কৰে। আৰু লগতে শ্ৰীমতী চিত্ৰলেখা কুম্বাং পেগু আৰু শ্ৰীমতী তিব্ৰাত দলতো ডিঙিত ধৰি বেয়াকৈ আঘাতপ্ৰাপ্ত কৰে। মানে লেটাৰ পাৰ্ট ইজ আই এম ডিফেন্ড মালত চোকা অস্ত্ৰ এণ্ড লাঠিৰে ইট ইজ মালত দিছ ইট ফৰ মালত দেয়াৰ ইজ সিচুৱেশ্যন ক্ৰিয়েটেড মালত চাম অল্টাৰকেশ্যন ইজ দেয়াৰ লটছিপ বিকজ দেয়াৰ ইজ এ মালত লটছ অফ ভেহিকল মালত দে also come from the opposite direction. We are going to the opposite direction. In that there is a matter some chaos is there also. I'm not defeated, but so far as matter the allegation matter sukada, how matter political party will go matter with sukada from training lot. These are totally false lots.
Everything
Just
is possible now.
no,
With
my lord.
sukada
How
and
it is
all.
going to campaigning lots with sukada? How can it be possible? And lathi my lord. Anyway, my lord, therefore tomorrow is the election, my lord, my vote is there, lordship. So it might be considered as an interim measure, my lord. I'll leave it measure. If
Yes,
something,
Mr.
my lord, then maybe rejected, my lord. My
Lordship, may kindly
right to
see
vote is
the
there.
forwarding, my lord. They are the main persons, my lord, who
Main person, 6 main
instigated,
person is there.
who instigated and wrongfully restrained the candidate and his supporters, my lord. And thereafter, they were assaulted and grievous injury was received by the PS of the candidate, my lord. These are all facts against them.
My lord, informant party also beaten us, our supporter. If my lord consider my lord, therefore tomorrow is the election, my lord, my right to vote is there, lordship. Considering the my lord, interim, at least my lord, bail may be considered if found, my lord. if something found my sukada lathi, etc. in the CD lordship, then my bail term may be rejected, my lord. Moreover, my lord, considering the fact that my lord remaining accused person granted bail in the police station, lord. To my knowledge, my lord, this is by fact, my lord. If my lord CD something is there, my lord, then maybe
That is,
rejected, lordship.
why he is kept
No.
behind bar? That is the one.
This is my wrong identification by the police.
That is the one.
By the
Oh,
info.
now you're saying he was not even there.
No, I was there, my lord, not involved in this activity, lord. Yeah, because this is a my lord, political campaigning process, my lord. Lot of my lord people get
Everything can happen in political
lordship,
campaigning.
lordship. Some altercation is there, my lord. I am not disputing, my lord. But so far, my lord, this part, my lord, later part, Sukada, Lucky, this part I totally deny, my lord. That's why, my lord, the remaining 5% whose name is in the FIR, my lord. Name is the FIR. They are granted bail, my lord, in the by the police, my lord.
But Mr. Digo,
It is considered, my lord. My vote is there.
but Mr. MP to submit it and it is a it's an application so so. Next, but submitted by Mr. Gauhati and counsel for the petition that this present petitioner is innocent and has not committed any such offense as alleged. However, it is a fact that during the campaign of two political party, there was a confrontation and quarrel between two groups, where some people may sustain some minor injuries out of the said scuff. But that apart, there is no other incident to this alleged. More so, there are six numbers of persons have been mentioned who were stated to be identified by the witnesses. 5 of them have already been granted bail from the police station, and the petitioner is the only person who got arrested in connection with this case. If others they did anything, the incident had happened only during the campaign process, and there was no, and there is, and the case does not also affect section 118 or 1172 as amended. But the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if it is granted with privilege. Next, Mr. Kusami Tilana petition will be submitted in this regard that from the forwarding report of the accused petitioner itself, the accused petitioner, it is seen that he is involved in the alleged offense and he was also identified by the witnesses on the basis of which he got arrested in connection with this case. Mr. Goswami accordingly submitted that there is a need of perusal of the case diary before passing any order of bail. Next, considering the overall circumstances of this case and and also considering the fact and circumstances under which the offense, the alleged offense is offense is alleged to have been committed. In other aspects of the case, this court is of opinion that interim bail may be granted to the present petitioner till secure the case. In view of this, the petitioner is aware of on interim bail for rupees 30,000, which wants you to like to the satisfaction of whose? Whose satisfaction?
My lord, CGM Dhemaji, lordship.
CGM
Lanet CGM.
CGM Dhemaji, but okay, will be under interim bail.
Lordship.
He may surrender within a such period. Lordship may kindly fix the date
Yes,
when
we are
he will,
fixing.
Lordship, my lord.
when he will surrender.
No, my lord, on the next day, my lord, lordship is called for the CD, lordship. On next day, my lord, if found something, I will surrender. Lordship direct.
Yes, when it can be fixed.
This my lord, first week of the next.
No, not because he was given an interim measure for
Then last
my
part
lord,
of
for
the-
the purpose of Lordship may kindly my lord hold that my lord for a limited period he has been granted bail in such cases, my lord. So he may surrender before police within some time frame, my lord. Because CD, my lord, we
Plus
cannot
CD
say my lord, if we fix a date, my lord, that on that date perhaps my lord whether CD will come or not, we don't know. My lord. There's-
Suppose CD, if CD comes
Yeah,
and found material, suppose
Suppo-
in that case, his bail will automatically be cancelled.
cancel.
In
So,
that case, police will be at liberty to
Lordship,
arrest
lordship, that is-
CD মালে আইস নিলাম
or you can surrender.
Proceed.
So it about
29
you want
29.
to say it is a
27.
month of April only? April
27.
27th of 27.
27 ভালো ডিপলি অবলাইশ
May I please your lordship? Here is a case where lordship, the petitioner is totally nowhere involved in the case. Lordship, something critical, I want to go by one and one. Lordship may kindly peruse firstly FIR, the page number 12. May I read, lordship?
Yes.
The informant's kind information is that the informant is the owner of Saddam Mobile Store of Kolgosia Bazaar on 23/1/2025 at about 12 a.m. An incoming call has come to the mobile of the informant from the mobile number bearing so and so, and he introduced himself as the owner of mobile shop in Abhayapuri. From that mobile number, regular 4-5 calls came and called me to Abhayapuri saying that he has some special discussion with the informant. Today, on 26 January 2026, at about 12 a.m., the informant came to Abhayapuri auto stand and meet the lady who called him from the said number. The lady was accompanied by another 2 male, and they forcibly pick up him in a 4-wheeler vehicle, and by kidnapping him, took him to a house near Dhoniam Memorial Hospital. Thereafter, in the said house, the informant has been detained, and 4-5 people brutally assaulted him, and his clothes were torn apart and made video with the lady. On several requests of the informant, the said people demanded that the informant rupees 10,000 and 56,000 has been snatched from his pocket. That was with him. Even after getting the said money, the more they demanded, firstly 46,000 and later 20,000 by reference number so and so. The informant was compelled to pay through phone pay bearing mobile number so and so. This is the allegation. Now, lordship, here in the FIR there is mention about 1 lady and 2 male persons. And now, lordship may kindly peruse page number 20. Page number 20, while the main accused to whom the amount extorted money has been transferred, this person was granted immediately bail on production because in the notice there was something wrong, and therefore the honorable magistrate was pleased to grant the main accused the bail on that day of his production. Now, lordship may kindly come to page number 24. This is the anticipatory bail order granted to those ladies. 2 ladies were there. These ladies are now under interim protection. Now the question remains, who am I? The petitioner here is Rukia Ahmed. The main accused, before 1 week of the incident, transferred rupees 5,000 only to this petitioner because he is in paragraph number 2. I have categorically stated he is the president of Junali Atmohahayika Matri Group of Kokila Nayapara. This accused person his family has taken some loan from this Atmohahayika Group, and as he is the president, he has transferred only rupees 5,000. And now police, due to this case, police is verifying his mobile phone to whom and where he has transferred money, and this amount has been shown by the police. Now police is after her. So, lordship, as the all main accused are in interim, some are getting bail. May I pray that other cases are fixed on 23rd of April, this case may also be fixed, and till then interim protection may be granted to this lady because she has no connection, totally no connection with this case. Only police is searching for her because some amount has been transferred from the main accused Abbas Ali to her force. This is the allegation. Only because of this, in the FIR also no name, no whisper of her name. She is totally not connected with the case. Only for rupees 5,000 that the accused person has transferred to her mobile. She is being searched by the police now. So, lordship, interim protection may kindly be granted. Till then, all cases are fixed on 23/4. All cases are fixed. Till then, I may be protected. This is my humble prayer, lordship.
Mr. Petition. Mr. MP Goswami, the learned additional people, every on object on. It's an application, section. Expert, it is submitted by Mr. Representative. And she is no way connected to the LS. And she is involved in the kidnapping of the informant, nor and money is being transferred to that figure to her in her account. However, ₹5,000 was transferred to her account by the family members of the as one of the family members took loan from her as she is working as the president of Junali Atmapahayika Matri Good. Apart from that, there is no other connection with the informant. There is no other connection with the presentation. However, on the basis of that said transfer of money, the police is searching for her and hence, she has an apprehension of arrest in connection. However, the petitioner is ready and willing to extend her cooperation in the further investigation of this case if she is granted with some information. Next, Mr. Submitted on a petition submitted that the case of the other accused persons fixed on 23rd.
Yes, 23rd, along with AB number 583 of 2026.
And so, and hence is submitted that CD may be called for the actual fact. Considering the submission made by the council of later. None of both sides, this court is that an interim protection can be provided to the further petition. Till this is public instead. So it's good. Let the matter be accordingly listed on date. You will be under interim protection.
Deeply obliged, madam.
May I please, Lordship? I'm sorry, my item was 47, Lordships. I could not appear, Lordships.
It is already gone.
CD may be called for at least, ma'am.
No, we have already listed it immediately after vacation.
Lordship, kindly at least CD may be called for. Because
We
I
have already listed it.
was in jam, Lordship, that's why I'm in.
It's already passed, order is only. Item number?
Only CD, Lordship, kindly, Lordship. Otherwise, only CD, Lordship.
No, we have already listed it after vacation.
My last thing also here, Lordship, kindly, my lord. I was in jam, Lordship, that's why, Lordship. I'm sorry, Lordship. Only call for case day, Lordship.
CDB call for
Lordship.
List the matter on 23/4. Item number 47.
47, Lordship.
Item number 10.
I am deeply obliged.
May I please, Lordship?
Yes, what is the position? Item number 10, scan copy you have received.
Yes, Lordship, scan copy was called for and received.
Yes. Yes,
So
please.
this is the second bail application, Lordship. First bail application was pre-arrest bail application, and pursuant to that order, Lordship, petitioner surrendered before the court below and prayed for regular bail. That was rejected, Lordship. Now, Lordship, trial is going on. And so far my information, Lordship, already 3 persons already been examined, 2 Caesar witnesses and informant, Lordship.
So your petitioner is in custody now, since when?
21/8/2025 till today, Lordship, 229 days, 7 months, 7 days. And so far the contraband is concerned, Lordship, 19 cough syrup and 288 capsules shown to have been recovered from the possession of from the house of the petitioner, Lordship. And at the time of recovery, the petitioner was not present at home. He was out. And now, Lordship, kindly see that we have annexed the
So as per you, how many witnesses examined?
3 witnesses,
Out of?
10.
Out of 10, man. Next
So
date
that-
is of my 24/3, whether
None, that
any
was,
action.
it is কোন একো হয় না, nothing but the mistake.
Record থাকলে নি? Record? খবর তো স্যার।
My first ground is that lordship. The contraband was not recovered from the conscious possession of the petitioner's lordship. Though it was shown to have been recovered from the house of the petitioner's lordship, and in the entire records I have gone through the record lordship, no specific place was not shown.
No?
In the house, which place that was recovered, that is not mentioned.
Place of
Only
recovery.
mentioned in the house of the petitioner that was recovered, lordship. In prose, lordship, in evidence, lordship, in affair, nowhere it is mentioned from which place that was recovered. And so far the Caesar witness is concerned, lordship, they would not, lordship, describe how many, the quantity of the contraband. That was not mentioned. And lordship, kindly say page 24. 2-3 lines, lordship, I want to show, lordship. Page 20.
24.
And lordship, this is the Caesar witness, Sulaiman Islam. Last line, lordship. Page 24. At the time of search and seizure, the accused was not present at the place of occurrence. And next paragraph, lordship. Next page, lordship. Middle, lordship. I arrived at the place of occurrence after the search and seizure. After completion of search and seizure, I have no personal knowledge regarding the capsules which were seized and recovered by police. Today, I have not seen the articles in the court. The police did not carry any typewriter printer. I cannot say the detailed description of the seized articles. This is one of the factors, lordship. It may be, suppose, lordship, something recovered. It may be small quantity, it may be greater than small quantity and lesser than small quantity. The police also, police after recovery packed the articles, thereafter took my signature. It is not a fact that nothing was recovered from the house of the accused. This is the one of the Caesar witness. In thereafter, lordship, PW3, that was not annexed. It is in record, lordship, wherein, lordship, I am reading, lordship, in prose. The police completed all the formalities prior to my arrival. Police completed all the form prior to my arrival. I did not personally see the articles. I have no personal knowledge as to where the articles were recovered. No magistrate was present at the place of occurrence. My signature was obtained on a white blank paper. PW3. And I have annexed the lordship, the informant evidence, lordship, page 29. Page 29, lordship, prose part. From bottom, lordship, 9 lines. During the search, no member of the family members of the accused was present. During the search, I have not collected any land documents, details of the house to show regarding the ownership of the house. In my affair, I have not specifically mentioned as to form which specific place the contrabands were recovered. The raid was conducted after sunset. Lordship, the informant also mentioned that at the time of occurrence, lordship, no family member was present, and here also, lordship, he confessed that, lordship, he would not mention the specific place of contraband were recovered. That is also, lordship. So, lordship, my humble submission is that, lordship, considering the evidence, lordship, both the Caesar witness and the informant investigation officers also, lordship, the articles were not recovered from my conscious possession, lordship. And since 229 days I am behind the bar, lordship, trial is going on, and it will take, lordship, another couple of months to conclude the trial, lordship. So, lordship, I may be considered to release on bail.
Yes,
My lord, Lordship may kindly see the regarding detention part, my lord. My lord, this is not a case, my lord. He is, my lord, for months he has been kept in the jail and no trial is going on, my lord. But may kindly see the dates, my lord. My lord, charges are framed on 23/9/2025. Thereafter, my lord, on 7/11, PW examined. Thereafter, they prepared a bail petition that was rejected. Again, on my lord, 21, another PW examined, and again 23/2/2026 was again PW3 examined, and after that, my lord, 24/3 is the next date. It is not clear what has happened on that date, my lord. So, my lord, the trial is proceeding at the right pace, my lord. And regarding the, my lord, now, my lord, this is a case of commercial quantity, my lord. So, the twin conditions has to be, my lord, satisfied, my lord, before granting of the bail. So, my lord, at this stage, my lord, Lordship, my lord, it cannot be held that they are not guilty because the trial has begun and yet to complete, my lord, and other witnesses are yet to be examined. So it is not a case that, my lord, he is languishing in jail for months, my lord, and no trial has been going on.
Lordship, I am on the,
Appreciating the evidence, my lord, at this stage. Yes, my lord, there are some, my lord, PW3, my lord, though they have stated that he was there at that point of time, but when crossed, my lord, he said that he has no personal knowledge. And this part is there, my lord. But other, my lord, but the other witness, 10 witnesses, total 10 witnesses are there, my lord. So he has to be examined. And from the evidence, only going by the evidence of one or two witnesses, it cannot be determined, my lord. So it's a case of commercial quantity, and he is, my lord, trial is, my lord, going at a nice pace, my lord. It cannot be said that he was detained and Article 21 has been violated against him. So, and Lordship may see the conduct of the accused person. He has absconded. He has absconded till the search sheet has been filed. He has not appeared, my lord. Your Lordship can see, my lord. Only after his bail has been rejected after the search sheet, my lord, he has surrendered from under the direction of the court. So, my lord, at this stage, my lord, his bail payer may not be considered, my lord, because your Lordship can see, my lord, there are multiple varieties of, my lord, NDPS items, my lord. Not only one, my lord, cough syrups, capsules, my lord. It reflects, my lord, he is a peddler. And Lordship, my lord, we have to see the balance also, my lord, between the, my lord, interest of the society and also the personal liberty. That has come from the several decisions of the Honorable Apex Court at this stage. At this stage, my lord, my petition may not be considered at this stage.
Lordship, I am on the merit part. My learned friend rightly says that section 37, Lordship, this condition does not apply in this case, Lordship. The quantity which has been shown to have been recovered from the possession, if your Lordship gone through the PW teaser witness, they would not mention the items which shown to have recovered from my possession. They have no personal knowledge. That is the part, Lordship. It will come, Lordship, when my seizure is confirmed. That part, that quantity has been recovered from my possession. And Lordship, and another aspect, Lordship, no conscious possession, Lordship. The prosecution has to establish the case, Lordship, that contraband was recovered from his possession. Along with Lordship, the accused had knowledge he had possessed the same, Lordship. Two aspects, Lordship, for establishing the concept of, Lordship, conscious possession. Knowledge is also required. Even, Lordship, something is recovered from my possession, conscious possession, even, Lordship, I am entitled to do it. If I had no knowledge about the possession of the contraband, Lordship. In view of the same, Lordship, 220.
Just because, my lord, he is not present at that moment, it will not grant him the liberty to, my lord, say that it is not from his conscious possession, my lord. It was recovered from his house, my lord. He has fled. And now he says it is not in from my that cannot be a ground, my lord, at this stage. A PW1, my lord, if your Lordship goes to PW1, but it stays, my lord. In that, I know the informant and also the accused. Incident occurred on such and such date. On the date of incident, police team searched the house of accused Jahinul Islam, who is resident of the village. I am the Gao Pradhan. On searching the house of the accused, police party managed to recover 19 numbers of cough syrups and 288 capsules, namely capsules, my lord. The articles were seized by police party and took my signature, my lord. So, my lord, that is, my lord, that is PW1 is specific, my lord. He is there, my lord. And thereafter in cross also, my lord. And it was no, I also do not know if the police, that is not important, police did not seize my identity card. I arrived at the PO. After the search, I have no personal knowledge regarding the capsules which were seized and recovered by. That means the
Quantity part is
capsules and my lord, regarding the cough syrups, my lord. He will not know he will only say that yes, it's a capsules and cough syrup. What type of capsule, what type of that part he cannot say, my lord. And I cannot say detailed description of sin. Police did not record my stand. Police after recovery packed the articles and thereafter took my signature. And he also denied the suggestion put to him that it is not a fact that nothing was recovered from the house of Jahinur. So well, only because it is not a case of, my lord, the small quantity, intermediate quantity, my lord. So section 37, the rigor is very much there, my lord. So seizure is from his own house, man. And search sheet laid down, now trial is going on, man.
Lordship, in FIR, Lordship, informant says that at the time of Lordship occurrence, the accused along with 2 persons fled away from the place of occurrence. Lordship, when he was examined, Lordship, he could not gather information about the 2 persons. Initially implicated them in the FIR, Lordship. And so far, Lordship, they projected the case that
Investigation part, it's not.
Lordship.
Lordship, initially they projected the case that, Lordship.
Okay, Mr.
After hearing-
Done a petition. Also, Mr. Ambiguous additional people appearing on behalf of state respondent. It's an application, 483 innocent, so it's so. Next one. It is submitted by Mr. Sir that the present accused petitioner is innocent. And nothing has been seized from the conscious position of the accused. Though it is alleged that some cough syrups and the capsules of the of commercial quantity was seized and resulted from the house of the accused petitioner. But there is no mention of the specific place from where it is alleged to have been recovered from the house of the accused petitioner. Further, it is the fact that the petitioner was absent at the time of seizure and recovery of the contraband from his house. He further submitted that from the evidence of the seizure witnesses also it is seen that they do not know the detail about the description of the seizure list and has no personal knowledge about the seizure. Mr. Sarkar further submitted that initially after filing of the charge sheet, he prayed for an anticipatory bail, and on as per direction of the court, he surrendered before the learned special judge on 21/8/2025, and since then, since last 7 months, 7 days, he is in custody. Charge has already been freed, and 3 prosecution witnesses have already been examined out of 10 numbers of cited witnesses by the prosecution. Mr. Sarkar further submitted that the 3 scissor witnesses, including the informant, has no personal knowledge about informant. This scissor witness has no personal knowledge about the recovery of the contraband. And from the evidence of the PW2, also it is seen that at the time of seizure and recovery of the contraband, no family members of the accused petitioner were present in the house. Thus, there is no evidence of any conscious position of the contraband from the accused petitioner. So, considering this aspect of the case vis-a-vis the length of detention already undergone by the accused petitioner, his prayer may be considered. The accused being a permanent resident of his address locality will appear before the learned trial court below as and when the date is fixed. Next paragraph. Mr. Goswami, the learned submitted in this regard that till the filing of the charge sheet, the accused petitioner was absconding and never cooperated in the investigation of his case. However, after his arrest, the charge was framed on 23/9/2025 and subsequently 3 PWs were also examined by the prosecution. Next date was fixed for evidence on 24/3/2025. However, it is not reflected in but however, it is known as to whether any further evidence was recorded by the prosecution on the date fixed. Accordingly, Mr. Goswami submitted that the trial is proceeding in a right pace and within a very reasonable period, 3 witnesses have already examined by the prosecution. And thus, it cannot be stated that there is any violation of Article 21 of the Constitution of India. He further submitted that the case is of commercial quantity and hence the twin condition has to be followed. But at this stage of trial, it cannot be held that the accused was not guilty of the offense or there is no probability of committing the offense in future if he is on bail to satisfy the twin condition required under section 37 and the case. Accordingly, he submitted that therefore petition may not be considered at this stage wherein commercial quantity of the contraband has been recovered from the conscious position of the accused petitioner. Accordingly, Mr. Goswami raised objection in granting bail to the petition. Okay, I have recorded your submission. I'll pass you on.
Public.
Let kindly pass over the matter for timing. Conducting counsel, no, sir, Azad Ahmed will appear. Published.
What is the position in item number 12 and 13?
CD
You have
was-
received?
Probably CD is.
Is it charge sheeted case?
No, my lord, CD was.
CD. CD is received.
CD was confirmed. The CD received, my.
CD received.
CD.
Okay, for time being, we can.
Lordship.
You will with waiting.
May it please your lordship, my lord, I am appearing in 2910/2025.
2910. That is on item number 16 you are appealing.
16, my lord. Though I'm not keeping well, my lord. Page 8 is the type copy of the FIR, my lord. Yes. I am on an interim. Prior to interim, my lord, after the FIR was lost, I was asked to appear before them and I was interrogated. I made a statement. On that basis only I was provided interim, my lord. In the FIR, my lord, some Brahmaputra, may I read it, my lord? We, Brahmaputra Biochem Private Limited, located such and such, filing the complaint on behalf of the company, we would like to bring to immediate attention a serious case of fraud, theft, and manipulation of company record committed by the following person. Number one, the Porshmani, I am for 1 and 2. Nature of work, the accused individuals were employed as weighbridge operator at our factory premises. Their primary duty is to accurately weigh incoming raw materials and outgoing finished goods to ensure inventory accuracy and billing integrity. Discovery of fraud during a recent internal surprise check done on such and such we discover significant discrepancy between the physical stock and recorded stock in our system. Upon further internal investigation and scrutiny of CC footage and log books, it was revealed that the accused have systematically stealing from the company. Then modus operandi, the accused have been manipulating the OEP's operation in the following manner: manipulating of weight, tampering with record, financial loss. Then, well, last but one paragraph, our further confrontation, they have also revealed that they are doing all this under the planning and guidance of Mr. Dipankar Kolita, store manager. He was their point of contact. So the head between all this is Dipankar Kolita. And my lord, I have made in my petition statements in my lord para 4 that my lord, I was called after the FIR for an my lord. Then my lord, I was called in my lord page para 10, my lord, para 10, 11 on 1/12/2025, 4/12/2025, para 10 and 11. I was called upon. On investigation and cooperated, and on that basis, I have been provided with an interim value. I think, my lord, I have given my statement also. Statement issue, na, madam? Statement issue. And my lord, page 13 onwards, the seizure list will provide that whatever is with us have been seized. My lord, your lordship will find, my lord, at page 13. From Navo Mohanto at page 13 and at page 14, Parashwani Das. And my vehicles were also seized, my lord, for both of us. Our vehicles, our mobile phone, everything has been seized. I am on interim. I have cooperated with the investigation. Prior to that also, I was called upon and I appeared and given my statement. We have a employee of the organization, my lord. The main head is the store manager, Dipankar Kolita. That is my submission, madam.
Yes, Lordship, otherwise allegation against the present petitioners is Lordship, they have manipulated companies. Huge amount of money has been manipulated to the tune of 30 crore rupees, Lordship. They're the employees, Lordship, of the said company. And they have, Lordship, their primary
34
work
crores.
is to weigh the incoming raw materials and to outgoing finished products to ensure inventory accuracy and billing integrity, Lordship. Main work. And the allegation of fraud, theft, and manipulation of companies' record, as well as Lordship, they have failed to give a proper accounts, and there is an imbalanced total discrepancy between the physical raw materials and the records that is on company's record. So anomalies has been found. And Lordship, accordingly, Lordship, they have done all this fraud, theft and all in collaboration with the transporters as well as the employees of the company, Lordship. And to that extent, Lordship, sufficient materials has been collected during investigation after going to the statement of the witnesses as well as the OAQ statement, Lordship. And also CCTV footages has revealed the fact that some manipulations has been done by the petitioners, Lordship. A huge amount of money has been manipulated, misappropriated by the accused persons in collaboration with other accused persons, Lordship. And there is a bail objection prayer also, Lordship. And along with these persons, Lordship, another accused persons, Dipankar Kolita, who is the main culprit, Lordship, under which instigation and under which guidance, the entire modus operandi. You are not the entire modus operandi, their custodial integration is highly required. I'm objecting their bail petition at this stage because interim was granted. before calling for the CD lordship. That may be vacated at the stage lordship. Their own statements reveal the facts that they have manipulated the entire things, lordship. They have fraud has been committed, theft has been committed, manipulating records as well as
From their own
overbeing,
statement. From their own
underbeing the-
statement.
lordship.
From their
From
own
their
statement.
own statement, lordship. It's not at all a fit case for granting anticipatory bail at this stage. No. I'm reading the statement of one of the co-accused, lordship. Corresponding does. মোৰ নামো ঠিকনা উপৰোক্ত মতে সত্য হয় মই বৰ্তমান জামবাৰী অৱস্থিত ব্ৰহ্মপুত্ৰ বায়'কেমিকেল প্ৰাইভেট লিমিটেডত ব্ৰিস্ক অপাৰেটৰ হিচাপে যোৱা 6 বছৰ ধৰি কাম কৰি আহিছো আৰু মোৰ মাহিলী দৰমহা প্ৰায় 14,000 টকা মোৰ মূল কাম হৈছে কোম্পানীলৈ অহা কয়লা মাকৈ আৰু চাউলৰ গাড়ী ওজন কৰা সঠিককৈ ৰেজিষ্টাৰ মেইনটেইন কৰা কিন্তু দীপাংকৰ কলিতা আৰু অক্ষয় কলিতাই আমাক কয় যে 14,000 দৰমহা লৈ কি কৰিবি তহঁতে মই কি কৈছো তেনেকৈ বেছি পইচা ইনকাম কৰিব পাৰিবি আৰু একো চিন্তা কৰিব নালাগে তহঁতৰ পিছত মই আছো দীপাংকৰ অক্ষয় আমাক গাড়ী নম্বৰ দিয়ে যিকেইখন গাড়ী ৱেট বহাই ধৰিব লাগে বহাই ধৰো আৰু যিকেইখন গাড়ী বহাই ধৰো যেনে লোকেল পাৰ্টি যেনে ৰফিকুল হক চৌধুৰী আছাম এণ্টাৰপ্ৰাইজ আয়ন এণ্টাৰপ্ৰাইজ চিৰাজুল আলী নামত সোমোৱা গাড়ীসমূহ কোম্পানীক বেছিকৈ হিচাপ দিওঁ এখন গাড়ীত 10-20 টনলৈ বহাই দিয়া হয় আৰু আমি নিজৰ কৰ্মৰ সময়ত যিমান টন মাল মাৰো তাৰ পইচা দীপাংকৰ কলিতা আৰু অক্ষয় কলিতাই আমাৰ একাউণ্টত দিয়ে আৰু কেতিয়াবা লোকেল ছাপ্লাই ডাইৰেক্ট আমাৰ একাউণ্টত সোমাই দিয়ে কয়লাৰ প্ৰতি টন 5-6 হাজাৰ টকাকৈ পাওঁ so they have intentionally with their full knowledge they have manipulated the entire products finished products as well as raw materials that comes to the company lordship this entire things has been done by them and Dipankar Kolisa is not cooperating with the investigation till now, lordship. They have failed to comply with the terms and conditions that have been incorporated. Therefore, their custodial interrogation is highly required because it's huge amount. The company has lost a huge amount. That is near about 30 crores of rupees, lordship.
As regards Novo and Poroshmani, that for which I am appearing, my lord, our bank account, our vehicle, our mobile phone, everything has been seized. Nothing is with us. And my lord, Dipankar Kolita, I am not appearing. My friend is appearing for Dipankar Kolita.
They're in the same bracket, lordship.
Lordship, may I please, Lordship, the item number 17, Dipankar Kolita, Lordship. As I have heard, Lordship, the submission of the learned PP is not cooperating, Lordship. I want to file a affidavit, Lordship, where I have cooperating, Lordship, and I went several times to the police station for recording my statement, Lordship. That I want to file a affidavit, Lordship.
But why your statement is not been
That I don't know, Lordship. Several times, Lordship, I approached to the police station, Lordship. Even the IO has talked to me, Lordship, many times. Now, if it come in the CD that if I'm not cooperating, Lordship, I want to file an affidavit, Lordship. And further, Lordship, that till we have obtained the interim, Lordship, there is no violation of the interim order, Lordship, which says that in spite of going several times to the police station, if it says that I'm not cooperating, Lordship, let me give an opportunity to file an affidavit, Lordship. Before this honorable then court may decide, Lordship, and possibly.
Is there any note on that in that regard that?
No, just now submitted, Lordship, that I'm not cooperating, Dipankar Kolita.
Yes, not.
There's a prayer from the investigating officer as regard to bail of granting, they're
He
opposing
never
the,
appeared.
because they are not appeared before the court, lordship.
Let me file, Lordship,
investigating
earlier
officer.
photographs and all, everything is there,
So,
time and all recorded, Lordship,
that-
let me file and detail affidavit.
The bail objection period is dated 33/2026, lordship. So it is categorically and specifically written that during the investigation of the accused person, namely Dipankar Kalita, has not cooperated with the investigation of the case as he has disobeyed the honorable court order that he has not appeared before the investigating officer till now to record his statement in connection with the above case. During
And
investigation of the
who
case,
is appearing for 18? You are appearing for 18, in 18 also you were on interim.
No, my lord, we are in interim, my lord.
You
We
were
are
on
the
interim.
drivers, my lord.
Just do one
So
thing. You
everything
cannot,
is done in
this-
collaboration
No,
with
no,
the
no.
transporters as well as the drivers. All are entangled, as well as the employees, Lordship of the company.
My lord, we are not the employees, my lord. First of all, we are not the
Kindly
employees, my
peruse the
lord.
Case diary and flag mark
No,
the
no.
relevant pages.
What I'm saying, a part order should not be passed there because
Yes.
he is saying that he wants to file an affidavit.
Lordship.
Let him file an affidavit.
Yes, Lordship.
In that case, we'll pass the order together. I have already otherwise recorded your submission and submission of Mr. Prakash
Lordship, Lordship,
as well also,
Lordship.
Roy Chaudhary also. But the question is that let all the matters be come up together because otherwise our observation may affect the other case. also.
Lordship.
That's why.
My lord,
Uh,
আপুনি কিমানত আছে? I think
18 or 19. Sheet as well, like.
17, good data, 16, 17, 18, heart, learning councils, appearing.
And the bank statements of Lordship also reflected the huge amount of money has been transactions between the co-accused persons, Lordship. Even in the name of wife of the accused, that is Dipankar Kalifal's name. In his wife's name, a huge amount of money has been transferred, Lordship. So I'm objecting the welfare at this stage.
Appearing to the petitioners and also part Mr. MS SH Pora, the learned additional PP, appearing on behalf of state respondent. CD is received, but it is submitted by Mr. Munir, the learned counsel, appearing in AB number 2977. That in spite of his appearance on several occasions before the police station, his statement is not recorded, and in that regard, he wants to file an affidavit poster. On the other hand, it is the case of the prosecution that in spite of the interim bail order, he never cooperated in the investigation and did not appear before the IO to record his statement. In view of this, let all the matters be listed together and updated case diary be called for. Further, the accused Dipankar Kalita in AB number 2977, 2025 may file his affidavit to that regard. And in the event he is not yet appeared and not if he is not even like if he has not appeared before the IO for recording his statement, the petitioner is hereby asked to appear before the investigating officer within 7 days from the date of order. Let all the matters be accordingly listed. 14th of May. You all are on interim, I think.
My lord,
All
all
are
are
on
in
interim.
interim, my lord.
14th of May, so and so. Updated case diary be called for, interim be extended till next date. If you have not appeared, suppose in any case, then you can appear Mr. Dipankar Kalita. You can appear within 7 days from the date of order. Otherwise, if you have already appeared, you want to file an affidavit, in that case, you can also file an affidavit to that regard. Because as per the prosecution, most probably have not appeared and not cooperated till date. So you may be one of the main culprit of this
But
case.
I was asked to sit in the police station for whole the day lot. Many times, if CCTV footage is called for lordship, it will reveal everything. I was there several times, lordship, they asked me and they kept me sitting for the whole day, lordship, as told by the petitioner. With the advocate also, junior, sometimes junior advocate also accompany him.
But whether his
Lordship,
affidavit,
objection prayer is dated 33/2026, Lordship. So Lordship may call for the updated CD. Lordship.
updated case diary will call for. In the
Yes.
meantime, if he has not appeared, he can
Lordship.
file an affidavit to that.
Lordship.
Now my question is that in regards to the other petitioners, is there any?
Lordship, otherwise,
I mean, the other petitioners are involvement is there, not
yes,
there.
interim was granted prior to the calling of the case diary, Lordship.
Yes.
Yes.
So they were
There were sufficient materials against the petition.
No, I'm not on there. Other petitioners, whether they are cooperating or not, that's what I'm saying.
Yes, Lordship.
Their statements are available or not.
Yes, Lordship, as per Parasmani is concerned, his statement is there. That is.
Logo is there.
arrested person are already released on bail. Lord. It is a case of Lordship 28/11/2025.
I'm not on that.
FIR, no, they want-
These are anticipatory bills. I'm not on that. Sirajul Azizul, their statement also. Lordship may call for the up-to-date case diary along with the statements of all the QEQs, Lordship.
Along with the statements. So what I'm want to ask, in regards to Dipankar Kalita, you're saying that he is not cooperating.
Lordship.
Whether bail order is available there in the case diary? His bail order?
Lordship.
His interim.
Bail order.
Especially for Dipankar Kalita.
Yes, Lordship, I'm just looking into it. Bail order किथे दिसते?
Bail order date to get.
Dipankar?
Bail দিছিল 18/12
আমাদের bail order তো আছে তেতে দিয়ে হইছে 30 day করে দিয়ে।
Nice.
The original certificate copy was taken by him, I would.
I have not found his bail order. Lordship.
Is collected.
Bail order तो नहीं।
No, the name, most really, he is saying that one certified copy was produced before the IO, but,
Not on Lordship.
but you are saying that, he, after obtaining that, he never appeared.
And the last
Not
report
corporate.
is bail rejection prior Lordship, that is on 33/2023. Till that, he has not
He
appeared.
has not.
Yes.
Okay. It is 14th of May. Well,
Highly obliged.
Much obliged.
Okay.
Highly obliged.
interim be continued till next.
21.
May I please, Lord?
Yes.
Lordship, in this case, when we filed this case, there is no FIR. And it's a very bail application, this was filed. FIR was, initially there is no
Yes, we
FIR.
have, received the copy.
AB.
Initially was not FIR.
No FIR.
Subsequently,
Subsequently, they have taken instruction that FIR was,
FIR
one
is-
FIR registered.
so CD
and
was called for.
CD was called for. And we have filed an additional affidavit.
It has already come.
Yes, Lord.
I said-
Okay. Where we annex the FIR. Lordship.
Item
Item 21.
21.
21. 417.
FIR is okay. Otherwise also we have called for a case diary. But
Lord-
what regards to your cooperation, have you appeared before the IO?
No, Lordship. I have not appeared.
Why? You were on interim
No,
protection?
no, Lordship. I have
You were not on interim.
Not on interim.
Yeah.
Lordship,
Lordship, there is a report that is on dated 11/03/2023. Submission of report. May I read, Lordship? On 10/3/2026, about 9:30 PM, the complainant, namely Swapna Wala Burma, is it about so and so, lodged a written FIR stating that she runs a microfinance collection group. She alleged that on 5/1/2026, the accused person, namely Asha Kaur, and her husband Babla Kaur collected money from the members of the microfinance group amounting to rupees 72,000 as daily collection money. They further assured that they would repay a total amount of rupees so and so, but till date they have not paid any amount. The complainant further stated that on so and so the accused persons took rupees 8 lakhs, and again on so and so they took rupees 22 lakhs 50,000, promising that the money would be repaid through monthly collection. However, they have not returned the said amount. When the complainant demanded the money back, the accused person allegedly used abusive language and so threatened to assault and kill them. Thus, they have allegedly misappropriated the microfinance money. Accordingly, the case has been registered by so and so, and the investigation of the case is in
The
progress.
case has already been registered on the last
Lordship,
occasion, it is on 13/3. It has
Yes.
already been stated that
So
case
to
is
that
registered
regard, Lordship, CD
under
was called
Nunmati
for.
PS case number 41/2026.
case
So
has been
accordingly, we
registered.
call for a case diary.
CD was called for, that is not received.
Lordship, our statement is page 4 in our petition, para 4, Lordship. Our contention, Lord.
No, it's okay. Your
CD is
petition,
required.
we are not on that.
No,
We are saying that
no.
case is registered.
Lordship, petitioner was called by the police on 10 February 2026.
Acha, you appeared.
Yes, Lordship. On that day, police called me over telephone. I appeared before the police, and nothing. I was there more about 10 hours in police station. Thereafter, police repeatedly visited my house. I searched for FIR. No FIR was registered. So I preferred this bail application before your lordship. Thereafter, on 27 February, this case was listed on as a motion item. Thereafter, on 10/3, report was called for. No report was received on that day. Next date was given 23 March. 23 March, this report was received by the learned public prosecutor.
So according
And-
to your lordship, case diary was called for that we have not.
And there it
received
is
this.
stated that in our additional affidavit, we annex the FIR. FIR reveals that the information received by the police on 10 March, when second time the report was called for. Police, but earlier when the instruction learned PP verbally submitted on 23, that police has conducted preliminary inquiry. That is why FIR was not registered. But FIR, the information was received by the police on 10 March. Lordship. Earlier occasion, their verbal submission is that police has conducted a preliminary inquiry. That is why FIR is not registered. But from the FIR, it reveals that FIR was received on, the information was received on 10 March. Lordship.
So let the investigation be carried upon, lordship.
Pardon?
Let the investigation be carried upon still the case has been registered.
It has already been raised.
CD is called for, that is not received. Another date may be given.
Lordship, protection may be granted.
CD number 6, we should remind him. He is not on interim, so when it can be picked up.
Lordship, just after
immediately.
reopening, lordship, any date as per the convenience.
21.
Lordship.
Till then, Lordship, in time protection may be granted.
No, your first date you have not granted with the interim.
Lordship, all the sections are available except one section.
21 for bail is calling for the case time. Be there.
Public.
This case, and for which they were shown as a tax on the intention. However, they may be in the chance for to appear with the data trial for failure and proper appropriate which may be considered. During this submission made by an also the annexure had along with the petition and the scanned copy of the PC. It reveals that these two petitioners were earlier provided with the interim 3 years bail, but considering their non-cooperation with the investigation, their interim prayer was rejected. And considering this aspect of the case, their subsequent anticipatory bail application was also rejected. Have seen that these two petitioners are repeatedly appearing before the court seeking anticipatory bail, and it may be due to their ignorance. They did not cooperate with the investigation after obtaining their interim arrest bail. So, considering all these aspects of the case, this court is of opinion that one more chance may be given to the present petitioners to appear before the internet trial court below with an appropriate application for bail, which may be considered in accordance. However, considering the submission made by Mr. Kuya, the petitioners are hereby provided with interim protection and
Summons were issued prior to my lord.
Summons. We have received.
The first summons were issued. Bisa kita ada ni. On that date, they could appear, my lord. The summons, there is a date in the summons.
Protection. Till the case is committed before the learned session judge by the court of city, by the court of city, by the court of learned city. Accordingly, no one corruptive actions have been taken against the petitioner till the case is committed. But the learned city may hereby direct to send the case, the committee case report for the learned session judge, preferably within 15 days from the date. So you'll be under some interim protection till case is committed within 15 days. You have to appear with a regular bail application before the learned trial.
Deeply obliged, your lordship.
Yes, please. Yes, what is 23? CD received here?
Not received.
You are on interim. You are on interim.
Yes.
CD not received. Issue remand. It will be extended till next date. Yes.
When communication is received, my lord, that they are in the assembly elections.
12th of May. 1.
Receive.
Much obliged.
What is position of 25? CD stand.
May I please, your lordship?
Yes.
Lordship, offense under section 103. Although, my lord, FIR at page 10, annexure 1, my lord.
Yes.
Relevant portion at 11, your lordship.
Yes.
Yes, my lord. The acquisitions regarding the assault, my lord, that they are a dispute over the money arose with the accused number 2. During this dispute, the accused persons, along with their family members, collectively assaulted the son with the punches, kicks, and spits, and causing him grievous injury. Subsequently, while being taken to the hospital in an injured condition, my son succumbed to his injury and passed away. This is the allegation, your lordship. And during the investigation, my lord, the 2 accused persons were arrested in this case, your lordship. Accused number 5 and accused number 8, they were enlarged on bail after completion of the statutory period, my lord. Now, so far this case is concerned, your lordship. The facts of the case is that the disease was succumbed not by injury, my lord, but succumbed due to huge consumption of the alcoholic, my lord, heroin, my lord. And so far the seizure list that may be available with in the CD, my lord, that in the seizure list, your lordship, what the investigating agency has seized, my lord, there are 2 numbers of plastic vials, and it is suspected to be vials contain drugs, heroin, and 1 BDU insulin syringe, and it is suspected to be used for pushing of drugs. Actually, my lord, the facts of the case, my lord, that accused number 5 and the disease, they were jointly consuming the drugs, my lord, and used to consume, my lord. On the fatal day of the incidents, my lord, that the disease consumed huge quantity of the alcohol, my lord, and because of that, he succumbed to death. So far the postmortem report is concerned, my lord, I have the instruction, my lord, there will be no any injury, my lord. So far the as well as in the FIR, my lord.
So you all are the same family members?
All are the family members, my lord. My lordship, in the FIR, my lord, 8 numbers of the accused are mentioned, my lord. So for the accused number 5 and the accused number 8, they were arrested, my lord, during investigation. And they were enlarged on bail, my lord. There is a absolutely, my lord, there is a no any assault injury will be available in the postmortem report as per the instruction of my client, my lord.
Yes, please.
Lordship, my lord. So far materials are concerned, my lord, the three petitioners are directly linked with the minor case, my lord. There is a dispute regarding the money when he went there to receive his money which he owned, my lord. The quarrel broke up and he was assaulted in their house, in the house of the petitioners, my lord. And after that, my lord, what they have done, they forcibly, my lord, they caught hold of him and forcibly, my lord, gave a drug dose, my lord, which made him unconscious. And thereafter he was taken to hospital and there he succumbed to injuries, my lord. This is the, my lord, version of the eyewitnesses, my lord. So very,
How the person saw that he was
they were the other persons were there in the house, my lord. Instead, witnesses of that person.
But he was called in the house of the accused.
Accused, yes, ma'am. He owns.
When the other persons were, means who were present there?
Other person were family members, my lord.
Do the other family members had the?
Yes, they were arrested, my lord. They were interrogated, and thereafter, my lord, this thing came to the light.
Oh,
my lord.
they were interrogated.
Yes, ma'am.
After their arrest.
Yes. Yes. So first of all, first, my lord, it looks like, my lord, there is a case of drug dose, my lord. But later, my lord, from the investigation, it revealed, my lord, he was first, my lord, beaten up, and thereafter was caught hold of, and he was administered my lord, some syringe, my lord, with a syringe, and thereafter he died. That is what the investigation.
Basically, 1,
reveals.
2, and 3.
Yes, specifically, my lord, 1, 3, and 4. My lord.
1, Mr. Tajuddin.
Yes, my lord.
3 is Saha Sultan.
And Mukhlis.
And 4 is
Yes.
Mukhlis Uddin.
Lordship. Zahir.
But where from those, as the counsel for the petitioner is submitting, from where these things were recovered?
Regarding, my lord.
Regarding the
Seizure.
recovery of the seizure witness?
From their home. From their house.
From their
From-
house?
Yes. Because he was there at that time. He was in their home. my lord.
So from their house only?
Yes. ma'am. Yeah. Okay.
The other family members means they present, who were also present in the house of the accused persons, that is the 5 and 8 were also got arrested. Also
Yes,
their
yes.
interrogation after.
5, my lord. 5 not arrested.
Not arrested?
He's in before your lawsuits, my lord.
No. Accused number 5. Not
Yes,
accused.
accused,
FIR,
yes,
FIR.
yes, my lord.
FIR,
Accused, my lord.
FIR.
Runjit
FIR.
Alam alias
As per F.
Yes, my lord.
June.
my lord.
Yes.
But, my lord, so far their presence are concerned, my lord. They were also present at that point of time, and they when the witnesses, my lord, when they came to know, the family members of the deceased came to know that there is a quarrel in their house, my lord. One of the person who go there, my lord, to bring him back, my lord. He was chased away by all these persons, my lord, and by telling that, my lord, we have just like we have assaulted, we will also assault you. So he, my lord, out of fear, he ran with the deceased person, my lord. He taken to the hospital, but he succumbed in the hospital. He was injured. This is the version of the so far the investigation. But the statement visible when we ask the accused person why they beaten Zahirul, they, my lord, Rahanul Islam, Taizuddin, Saha Sultan, Muklesuddin, Arunjit Alam, Kitabuddin, then my lord, Razida Khatun, Suhana Khatun, became aggressive and chased us, shouting, "Leave this place and get out, otherwise we just we'll beat Zahirul. We will beat you just like we beat Zahirul."
All
Will
these
happen.
aspects, my lord, submitted by my learned friend, whether it is corroborated with the postmortem report or not. Had there been any assault, my lord, definitely revealed from the postmortem report.
Yes, what is the PM report say?
And so
PM
far the
report-
seizure list is concerned, my lord, I have the copy of certified copy, my lord. I have already submitted, my lord. No arms, no ammunition,
No,
nothing
that
was
is- the
recovered.
Arms ammunition question is doesn't have. Yes.
The final, my lord, final postmortem report is pending, my lord. It was kept pending, my lord. So that will come only after the final report is yet to be received as per the my lord, last my lord, IO report. my
But is there any opinion framed by the doctors that
Yes,
he
as
died
per
out of sweat?
there is no poison that is stated.
Huh.
There is no poison in the stomach or other.
Huh.
But the report,
No poison, but any other injury?
no, that is not specific. It said only there is no poison, but the report will come only when the FSL expert gives the report to the my lord doctors, my lord.
Viscera has already.
Yes, who will form the opinion regarding the death.
But so far the preliminary that report, my lord, that reveals a no assault, my lord. But so far the statements of the this informant and other witnesses are concerned, my lord, regarding the assault, my lord. There is no any assault, my lord. Everything are concocted, my lord.
And my lord,
They were, as per the facts of the case, my lord, that the accused number 5 and the disease, they were jointly consuming the alcohol, my lord. And so far the disease is concerned, he consumed excessive alcohol, my lord, and succumbed to death, my lord. This is the facts, my lord. And so far the assault part is concerned, apparently from the FIR, my lord, and already my learned friend has submitted regarding the other statement, my lord, but not corroborated with the postmortem report. Had there been a single injury, my lord, definitely that will be revealed in the postmortem report.
one injury is there. It is a mild blood mixed fluid and foam coming from the nose, my lord.
No, that is after this accident.
Lordship. Mild. No, it is
Those are
as
not-
per the it is as per the inquest report.
No, it's okay. I'm
Yes.
not on that. I mean, blood may come out, but whether the injuries were there, that is not.
Not
probably
specific.
not specific.
Not specific.
And the blood might have come out because of those
Consumption.
doses and all.
Doses,
Maybe, huh?
yeah,
Maybe.
mixed
Maybe.
fluid.
I don't know.
Yes. But that's super because we cannot ignore the version of the my lord. Eyewitness man very specific, my lord. They stated, my lord.
Because
Just
otherwise he wasn't drug addict.
Yes. What he said when Zahirul demanded money, Rahanul quarreled with him and situation escalated. I saw with my own eyes that such and such Zahirul by punching and kicking them, causing serious. I saw them forcibly administer drug into Zahirul's body, leading to an overdose. A very specific man.
One part, my lord,
Good,
saying
good.
that excessive,
But we came to
given
know
the
that-
excessive alcohol, one part saying the assault, my lord.
Given
The contradictory
there is no,
persons are,
there
my
is
lord.
nothing that excessive alcohol, my lord. It is not a part of investigation. It is only.
There is no any
So if
injury,
it-
my lord.
So if you want to wait for the my lord, PM report, my lord, specific report, that is a different thing. Otherwise, my lord, materials are against them.
Mr. S.K. Jain, the learned consultative part, Mr. M.P. Goswami, the learned additional PP, applying on behalf of students. It's an application, section Wednesday, action bits. CD received. It is submitted by the and the representatives petitioners are innocent and they have not committed any such offense as alleged here. The fact that there was a quarrel between the accused person and the deceased for some money, and but thereafter the accused number 1, namely one Arunjit Alam and the victim together had consumed alcohol as well and they were also injected with drugs that is heroin. Subsequently, due to overdose of the consumption of drug, the deceased fell unconscious and subsequently died in the hospital. But there was no such assault on the victim as alleged in the affair. To that aspect, the two accused persons, namely accused number 5 and accused number 8, had already arrested in the case. They already arrested in this case. But the present petitioners are no way connected to the alleged offense, except quarrel for the monetary dispute. The first of all, the petitioners are ready and willing to extend their cooperation in the further investigation of this case if they are granted with privilege clearance. Mr. Kusami, the learned additional people submit this regard that till date the final opinion for date is not received, as the FSL report is not yet received from the laboratory.
The FSL received, my lord.
Oh.
It has to be given to the my lord for final opinion, my lord. Then
So
only
what the FSL report says, no
it says
poison.
no poison, my lord. It
And
says
who will give the final opinion?
again the doctors, my lord. Because
Tell us.
now I prepare to take necessary step to submit a requisition to the medical for obtaining the final opinion regarding.
Final opinion is not received, though the
Regarding.
FSL report has already been received, wherein it is stated that no poison was found in the viscera of the deceased. Mr. Kusam also admitted there is no other injuries found in the no specific mention of the injuries in the PM report. However, blood was coming out from the nose of the deceased at the time of the examination, as well as at the time of test. So Mr. Kusami further submitted that as per the witnesses and from the statement made by the two accused persons, it is seen that the deceased might have died due to overdose of the drug which were injected to him forcibly by the accused persons after the quarrel. However, till date, the final report is still awaited from the doctor. Mr. Kusami accordingly submitted their sufficient materials against the present petitioner, who not only assaulted the victim but also forcibly injected overdose of drug to the victim. Next para, considering the overall circumstances of this case and the PM report, etc., I find that this court is of opinion that one chance may be given to all the petitioners to appear before the IO and to record their statement till regard accordingly not provide good better interpretation, and the updated case diary along with the final opinion of the death of final opinion in regards to death of the deceased may be called for. Will be under interim protection, appear before the IO, cooperate in the investigation.
The final order will be as per the my lord CD, my lord.
Yes.
Because
13th of May.
Deeply obliged, ma'am.
1-3.
Deeply obliged.
May it please the lordship. This is a 482 application where seeking anticipatory bail application for the petitioner. Your as per the direction of this honorable court, last 15 and 7, the petitioner was appeared before the IO for the interrogation, and almost 2 days, 10 hours they have been interrogated. When the CD was called for, petitioner is the shopkeeper of gold shopkeepers, So one theft incident of theft was happening at Nomuli, Thereafter, my lord, one person was arrested. Thereafter, my lord, the Numaligarh police station came to Ambagan and they have searched to the petitioner house as well as the shop, my lord, and nothing was found. In fact, one bike was found. They are forcefully taken without giving any seizure list. They are forcefully taken to the bike by the police, lordship. That is the case. Now, lordship, last time, and I have mentioned, my lord, paragraph 9 of my petition, my lord, one person he do not know about that person. He came to his shop and trying to sell some gold ornaments, but he's refused to take that gold ornaments, and he is asking money from him. He is also because unknown person is not giving. Obviously, nobody is giving any money to him. So in that regards, might be a police came. So now the residual.
Yes.
My lordship, he has appeared, my lord. In his statement, my lord, he says, my lord, that he is a goldsmith by profession. And my lord, one person came to him to sell gold. But I suspect that these gold ornaments might be stolen, so I did not take the gold. And he gave the phone number of the person who has given the, my lord, who have came, one Izazul Haq, he has given the phone number. And when police came, he said he absconded. That is his version in the interim matter. And
No,
other-
not absconded. At that point of time when police came, at then time, fortunately he is not at home, my lord.
This is the version of the his own statement on intent. And
So, my lord, nothing
now-
is found, my lord. Any
But
stolen.
so far the IOS report is concerned, my lord, he suspected that he has concealed the gold that has been, my lord, stolen gold. And there is also another case pending against him. These are the materials against him, my lord.
Order to put.
Against him.
Against him, my lord.
No, my lord, that
Eh.
earlier case he is acquitted. Anand order.
No, one case. One. Now another case is registered at Nagaon Police Station, case number 146 of 2026.
Okay, there may be another case, but here in the instant case, there is no such recovery. And as
no,
per
this
police,
case,
my lord, nothing
he may conceal those.
Yes, man, that is the.
But in this case, nothing is found. And maybe case may raise that is on a suspicion basis because
Why
he is.
you engage yourself in taking this theft ornaments, you know?
No, my lord, I am
To
not.
avoid it. Be a goldsmith. Or it's okay. You have a jewelry shop.
No, my lord. See, my lord, what happened, my lord? I am the shopkeeper of a gold. So many people came to me.
Do your own job.
So how can I know
See,
this
that's
person
that
is?
is not for the submit a learned application PP being on an application section it is submitted by Mr. Dutt and the application is nothing has been from his position during such however, after obtaining the order of template spell, he appeared before the eye and cooperated in the investigation. He is still ready and willing to cooperate to extend his cooperation in further investigation. He is granted with the privilege of the that it is a fact that there is no recovery from the position of the investigation, but as per the report of the IO, he might have concealed the gold ornaments which he received in the present case. However, the effective petitioner appeared before the IO and cooperated in the investigation, and his statement is according to recording evidence. But considering this submission, the well and counsel proposals materials available in the case diary and conduct of the scored is that he may be granted. No. According to so and so, the therefore pre-arrest bail is hereby allowed. And according to the order of interim pre-arrest bail, dated 13/03/2026, is hereby made absolute with same terms. Appear before the IO as and when it will be required. Otherwise, your petition is we have given you absolute.
Yes, my lord. Anytime if IO call, my lord, he is available before the IO.
Another speaker, kindly record regarding he was in other office. Will type of
He is,
habitual.
a case is also registered. It is submitted by Mr. Goswami as per the police report. Another case is also registered against.
Much.
May I please your ladyship. Ladyship, to case diary is not as received as far as I'm informed. My ladyship, I just request the ladyship for 3 minutes to make my submission, my ladyship. Though case is not, it's a fit case, my lordship. It may see the case diary and not be necessary.
What is submit?
Ladyship, I'm praying that
Ah.
this is the fit case, so ladyship may not necessarily the case diary can give me the interim protection, my lady.
Called for by one order.
The CD was called.
Called for by one order. Again, how we can say the CD not happening? It was already CD called for.
My lady,
CD
can
not
I?
received-
CD called for.
Not received.
No, what is submitting? I could not follow you.
My lady, may I just pray for 3 minutes, my lordship.
No, what do you want to submit?
I'm submitting that co-accused are released on bail. None of the sections implicated not applied to me, my lady.
No, we don't have the receipt case diary. That's what.
But the
In the
victim
initial
stated in the
you
my
are
lady
not
the
granted with any interim
my
protection
lady yes
on the
my,
first day. So at this stage, we have
my lady the
considered
first day your ladyship was
petition.
called for the
We
short
want
time in the
to
case.
for.
Yes, your lordship in the last time last occasion called for the case time
Yes.
is a short time not hard mail lordship.
We call for the case diary. Two cases diary were called for. One is from Punari PS, most probably 08 of 2025. And the GR corresponding to GR case number registered so and so. Only one.
Only one.
It is somehow.
Who is arrested, my lady? I've submitted
Chunari,
the last time.
CHUNA. It's not CHU, I think. Soniki. Sonari is SONARI.
Yes, but not yes.
Sonari, we have wrongly declared as Sonari, but Sonari P. So let the CD be received. You are not behind the bar, isn't it?
But I might be apprehended arrested
No, what
anytime.
to do? It is 109 is there. What to do? Say, what to do?
That particular section will not be.
How can we say now without perusal of
Victim is stated in the
Chonari, na? Chunari.
Yes.
Oh, acha, I thought that Sonari Jorhat. Okay. City not received, issue reminder. We are immediately after vacation, we are listing in. Your matter, let it be on 2020. Usami, let it be on 2020. 20 kahi papoda.
20.
Let it be on 22 because 20 very, there is no probability of receiving CD because up to 19th is a holiday. Days are holiday. So let it be on 22nd.
22nd of that.
22nd of April.
29.
FWS.
May I please, the lordship, this is second bail application, your lordship. In the earlier bail application also as per order dated.
You have received the case diary here?
Your lordship. No, your lordship, actually, your lordship, in the motion stage, first date, your lordship, we showed time, your lordship. And to the second date, your lordship, it has come in the bail hearing list, your lordship. And your lordship, my simple, my praise limited, your lordship, on page 27, your lordship. Your lordship was pleased to extend 15 days time, your lordship, to appear before the trial court, your lordship. But lordship, after receipt of the certified copy, your lordship, the father's name was different, your lordship, as per your lordship, remember, your lordship, I filed an IA, your lordship, but the father's name was different, your lordship. And your lordship asked me to withdraw that IA, lordship, and to file a fresh bail application, second bail application. Accordingly, your lordship, I filed this second bail application, your lordship. Your lordship, my prayer is simple, your lordship, as interim was allowed, your lordship, on the last date, your lordship. My interim may be made absolute, your lordship, and after and it is a session tribal case, your lordship. On my appeal,
May be absolute. Why? How?
the case is charged, your lordship. On page 28, your lordship, I appeared before the IO, lordship. My statement was recorded, your lordship, and accordingly, 15 days time was extended to me to appear before the trial court, your lordship. But on receipt of the certified copy, your lordship, the father's name was different, your lordship. As per your lordship, may remember, your lordship, I filed an IA, your lordship, where I asked for correction of the father's name, your lordship. Accordingly, the IA was withdrawn, your lordship. And this is second bail application, Your Lordship. Father's name to different, I think they are all- the father's name, Your Lordship, is the identity of the petitioner, Your Lordship. And as per Your Lordship direction, Your Lordship, I withdraw that IA, Your Lordship, and I filed this second bail application, Your Lordship. 15 days, Your Lordship. But as Your Lordship, it is a session tribal case, Your Lordship, under section 118 and 109, Your Lordship. I may be put behind the bars on my appearance before the JMFC, Your Lordship. Your Lordship, on receipt of summon, Your Lordship, I will appear before the committal court, Your Lordship. And this interim bail application, this interim bail maybe need absolute, Your Lordship. My simple.
Because you were on interim earlier.
Yes, Your Lordship. I mean, this interim. The
Because I
JMFC
I can remember one petition was filed by her.
Yes,
Seeking for one modification of her father, but father name is the identity means, so we didn't allow it.
Page
I think
29.
29.
last
Last week.
No, that is different. That is to we gave 15 days for so and so, but thereafter they came with an application that his father name was
Yes,
mistaken.
in this petition, my lord, the father's name is different, where your lordship has directed to appear within 15 days.
Yes.
Here, my lord, it is Moinuddin, son of Abdul Rahman.
actual name is Azmat Ali.
Asmat Ali. That is why they paid for correct.
Hmm.
But after that, they withdraw the
I
now, my lord, you might think that in page 29, your lordship has extended the for 15 days to file a petition.
Lordship, my interim made absolute, Your Lordship, on my receipt of summon from the trial court, Your Lordship. I will appear before the trial court, Your Lordship. It's my simple prayer, Your Lordship.
Otherwise, from the statement, it seems that he cooperated with the investigation.
Yes, Your Lordship.
As per the order, it was.
Yes, Your Lordship. At para 1, 2, 3, 4, fourth para, Your Lordship.
Pardon as Narjan, the petition. Goswami did not addition. This is an application. CD not received. No, CD now scan copy. What we call for? We call for.
No, does not call for.
Oh, not call
for
for.
motion, my lord.
Acha.
Came, my lord, wrongly came for my lord.
Bail hearing.
Acha. So and so. It is seen that the application has come wrongly at the hearing, though it ought to have been listed in the motion part. So, however, it is submitted by MS Nasrin that earlier the present petitioner got the interim protection, and accordingly he also appeared before the IM, and his statement is recorded by the police during investigation. But after filing of the charge sheet, the petitioner was directed to appear before the learned trial court below with a regular application for bail, and his interim protection was also extended for 15 days. But but while he was about to appear before the learned trial court below, it's come to the notice that the name of the father was wrongly mentioned in the earlier bail application, and for which one more interlocutory application was also filed for modification of the correction of the name of the father. But that was subsequently withdrawn by the petitioner, and the praised bail application has been filed for this court. Next, Mr. Goswami, the learned additional PP submitted in this regard that he may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance. Next, in that context, MS Nazdin submitted that as the case is of is of succession tribal in session tribal, there is every probability of his arrest if he appears for the learned trial court below before the committal of this. During this submission made by learned counsel for so yes, and the annexures file along the petition, bring the petition. It reveals from the annexure 5, that is the order, it is 16/26, that in pursuant to order of interim order granted to the petitioner, he appeared before the IO, cooperated in the investigation, and his statement was also recorded by the IO during. But at the time of listing of the earlier case, the case was already charged sheeted, and for which he was provided further 15 days with interim protection, along with a direction to appear before the learned trial court. But as the reason stated above, the petitioner could not appear due to a wrong mentioning of his father's name. Next, considering the entire facts and circumstances of this case, the cooperation extended by the accused petitioner, this court is of opinion that his interim bail granted to the accused petitioner dated 16, wherever interim bail was, when it was granted.
Yes, Your Lordship.
Your earlier interim bail was granted on which date?
On 18/11/25, Your Lordship. That's
Have you annexed the order here?
the order dated here, page 24, Your Lordship. Annexure 4, Your Lordship. 18/11/25, interim was allowed, Your Lordship.
You could say. It is 18/11/2025, fast in AP case number 2732/2026 is hereby made absolute with same terms and conditions with a further direction to the present petitioner to appear before the learned trial court below with a regular bail application. On receipt of summons, with the above observation, the I extends. Okay, you absolute bail you are granted
Yes, Your
with a
Lordship.
further direction for regular bail.
Deeply obliged, Your Lordship.
This criminal petition stands dismissed. It has been observed that no is rightly convicted under section 304 part 2 and 324 IPC, and then accordingly we do not find any reason to make any interference, and the criminal appeal is dismissed. Your number? 30. Okay. Is it 30? Three zero 30. Yes. Here we have received the scan copy.
Here in this case, my lord, here in this case, my lord, the FIR was lost against the petitioner, my lord, under section 4261, 471, 468, 420, and 409. Subsequently, charge sheet also submitted, my lord. Due to my lord, his certificate, matriculate certificate, he is a school teacher, my lord. His matriculate certificate was effaced, my lord, by him as per allegation, my lord. Subsequently, notice summons were issued, my lord, from the lower court for his appearance, but the petitioner could not appear on three occasions, my lord. Thereafter, proclamation of notice issued, my lord. That's why he has not appeared before the court and before your lordship for a protection, my lord, since he is still in the service, my lord. In the event of his appearance, my lord, he may be arrested,
Meaning he was shown as an absconder.
my lord.
And thereafter, in
In the
spite
charge
of
sheet also,
receipt
my
of
lord.
notice, he did not appear.
No, my lord.
And thereafter, NBW and now PNA has been issued.
My lord.
Now we are seeking protection.
My lord.
Lordship, in the prayer for Lordship, my learned friend has challenges the order of the trial court, whereby the learned trial court has framed charges against the petitioner, as well as my learned friend has also challenged the order of the search Lordship. So how come Lordship we make?
I have not. This is the anticipatory bill, my lord. I am not.
Yes, anticipatory.
I am not
Lordship,
challenging
come
the
to page 2, Lordship. The
page 2.
Page 2. So the matter pertaining to so far as the grievance is concerned, as per my learned friend's statement,
for
Lordship,
his-
he has come against the order dated 6/8/2024, and the charges has already been framed. Then he has also come against the search where he is found to be absconder.
That part I am not denying, my lord. My prayer is before your lordship. I may be allowed to appear, my lord, so that I can.
No, in anticipatory bill, how come these things you have
My
That
brought these
cannot be
things?
the prayer portion. It should not be like.
And my prayer part is that my lord should not be granted PST bail in connection with PRC case number 702 of 2024.
The
pending
cost
before
title
the
shows
learned
that he has come
additional
against the
cases.
framing of charge order as well as the search, washing of the search.
Allow the petitioner
And
to appear on the next day.
what nature of case you want to, your prayer portion also, prayer is bill in connection with so-and-so pending before
Before the
so-and-so, and
additional
allow the petitioner to appear on the next day, that is on 33, to face the trial, and after hearing, be pleased to make the order absolute. Means what you're saying?
My lord, in fact, my lord, I am praying before your lordship for a protection so that I may be interim protection, maybe so that I can appear before
No,
the
but
court.
your prayer doesn't say so. After hearing make be absolute. What order will make absolute? Is there any other interim order? I don't think so.
No
And
interim
that apart, she is rightly submitted in the bail application. How you can challenge the charge sheet, then the orders of framing charge and all? You cannot challenge all these.
My lord, I am not at this stage. I am not challenging, my lord.
You have challenged. Your cost title shows. Your cost title shows. No, why you saying no? Yes, you have challenged.
My lord, praying for my lord.
No, whatever
first,
you,
para one,
you
my
have
lord.
challenged these things. The charge sheet also you have
Praying
submitted.
for granting, my lord.
No,
first page.
whatever you have challenged all these things. The charge sheet you have challenged. The charge you have challenged. Your entire cost title is defective. How can it be entertained?
In that case, my lord, I may be allowed to withdraw this petition and file a fresh one. Since my lord, next date fixed on 9/6/26.
You're Mr. Alam.
Yes, ma'am.
Part Mr. I Alam, the done responsibility petition. Also part Ms. S.H. Kora, the done additional PPA payment on behalf of state respondent. At the time of deliberation, the case
in the matter of
as pointed out by MS Kora, and also from the record itself, we see that the cost title of the petition is defective one in that regard. Mr. Alam submitted that he may be allowed to withdraw the same with the liberty to file a petition. Considering the submission made by Mr. Alam, the prayer for withdrawal is allowed. However, the petitioner is at liberty to file a fresh application for bail. With that observation, the present AB stands dismissed. Okay, you will be at liberty to file a petition.
My lord, I will correct it and file it.
Yeah, both the case arising out of same FIR, Lordship, and all were arrested on 3/3/2026. FIR, your Lordship will find page 11.
Yes.
May I read, Lordship?
Yes.
I would like to report that I am an unemployed educated youth and was searching for GOV job under GOV Railway Department recruitment circular for job vacancies was opened. About 15 days ago, accused Motiur Rahman, son of so-and-so, village so-and-so, talked to my father, Mohammad Amir Hussain, stating that he had good relationship with some railway officials and they could help me and others to get the job in GOV Railway Department. Today on 2/8/2026, 2/3/2026 at about around 12 p.m. as told by Motiur Rahman, I along with my father, my cousin Rosida Khatun, she also applied for railway job, and Mohidul Islam, aspirant for railway job, came to the Daffodil Hotel, Palton Bazar. There Motiur Rahman introduced the other two accused persons, Shankar De Sarkar, so and Subhan De Sarkar. They are in the next item, Lordship, these two petitioners, accused as officers of GOP Railway Department. Both of them also introduced themselves as electrical engineer of GOP Railway Department. Then all the accused persons took PAN card, Aadhaar card, educational qualification certificate, etc., documents of me, Rosida Khatun, Mohidul Islam. They asked us to keep ready rupees 2 lakhs in cash for each to get the railway job. Conversation was not satisfactory, and we asked them to show identity card. Then accused Shankar Das Sarkar showed one identity card but did not allow to take photo. Later, we brought them to the Palton Bazar PS and came to know that Shankar De Sarkar, Subhan De Sarkar are not railway officers, and they have shown false ID card, and all the three accused persons have the conspiracy since long, and they have taken money from many job aspirant persons by cheating and preparing false identity card. So this is the allegation. As per my humble submission, Lordship, offense did not take place. Prior to that, they took the persons to the police officials, Lordship, and the affair was lost. And today, as on today, Lordship, they are in custody for 36 days. And they also were in touch, Lordship, the informant side. They also went to that hotel, Lordship. They wanted to hand it over those monies. Those things are also there, Lord. And considering the length of detention and that they have not taken the money from the informant, Lordship, that offense did not take place. Lordship may consider at this stage, Lordship. Mandatory period is 60 days, and because they have handed over the accused persons to the police, Lordship, so 35 notice was not given. Otherwise, had it been a case directly lost to the police, Lordship, they would have certainly issued notice under section 35P, Lordship. But because they were handed over to the police, so that part has not complied.
Yes, my lord. Yes. My lord, as per the FIR, my lord, the accused persons, my lord, they lured the victims to give rupees 2 lakhs for the job they will be providing in the railway department. Accordingly, they my lord, called those my lord, victim persons to one hotel, my lord. There they demanded 2 lakh rupees, but in the meantime, they become suspicious of the nature of the business, my lord. So, my lord, they took them to the police station and handed over to the policeman. That is the case.
But is there any thing that in earlier occasion also there were such kind of incident that happened?
My lord,
Or
that is yes, my lord. This came out from the statement of the accused. they stated the हमने तो दिखाया था वो हमने आईडी दिखाया लेकिन वो फेक है ऐसे ही हमने अभी तक बहुत लोगों को धोखा दिया दिस इज
अच्छी बात
अच्छी बात में and informant also my lord, they are also not at my lord.
they're they're ready to provide 2 lakhs each. Three persons were there when they came. So backdoor system, they wanted to
they want
get
to
a job.
yeah the problem.
36 days, Lordship, they will cooperate with the further investigation and also will face the trial, Lordship, if they have done anything.
They are not from Assam?
They are not.
Petitioner, in one person, they are from Assam, Lordship. That item number, DA number 737, Lordship.
737.
Yes.
Motiu Roman is from Assam.
Yes, he is from Assam. Other will Lordship may impose any condition, they will comply with.
One is Sankar De, Sarkar.
Local surety may be.
The definition of local security is very tough. Anyway.
Very tough.
But Mr.
Once they are gone, my lord, it's very difficult.
Very difficult. But Mr. A, 6th parallel bracket. So in connection with this, CD received paid receipt. Next, submitted by Mr. Ahmed at the accused petitions 90% plus 36 days. Considering their period of detention, they may be released on bail. But if is submitted on the statement made in FI itself, it is seen that no offense took place as they were immediately brought before the police station on suspicion, and in that case they were also not provided with any notice and a second appearances. However, the petitioners are ready and willing to extend their cooperation in further investigation of this case if their cooperation is Mr. It further submitted that police got sufficient opportunity to interrogate the present petitioner, keeping them in custody, and hence further custody interrogation may not be necessary. If Mr. Goswami did not that from the medical certificate is that it is seen that these are the persons who these accused persons were introduced themselves as a review officer with some fake identity, and the accused person themselves admitted that they they were shown some fake identity card, and later on suspicion they were brought to the police station. It also reveals from the record that in some earlier occasion also they were involved in such type of cases. Next hearing is submission made by Rani considering the case died and also considering the length of detention given by the investigations. The find that police got sufficient opportunity to face the petitions, keeping them in custody, and hence further custody interrogation may not be necessary for purpose. बाकी अपने it will be Palpan Bazar,
Lordship.
CGM Kambu, CGM Kambu,
CGM.
and there has to be some conditions which occurred and one government security, two security with one government security.
I card that voter ID, voter ID.
Voter ID.
Voter ID. Apply.
Exactly. Where are those? Any-
Lordship,
Yes,
kindly pass over the matter for timing.
timing is,
I see no legs on
we don't
another.
have timing now. It is almost 2:20. Your senior is not here.
See, another.
It is need for timing, but it may not reach. Huh? Okay. So there are many matters.
Please, Your Lordship. Lordship, up-to-date CD was called for.
Up to date CD not received. Lord.
Not received.
CD is there, but it is not up to date.
Up to date is will be required.
Not.
Case
Because
is not,
some,
is not yet charged sheet.
it is a no. It is charge sheet. Not charge
Not
sheet.
charge.
Not charge sheet.
You are MS?
A.H. Attia.
Hard MS AH Atya, Ilanet Public for it. So hard district. KK that's Ilanet additional PPA on the state. It is submitted by Mr. Das that the updated case date is not received as called. It be opens. That do you want any fixed date here?
Yes, Your Lordship.
Fourteenth of May. Updated case diary because. Okay, we're calling for the updated case. Hopefully, it may reach by 14th.
Much obliged.
May I please your leadership? May I appear for the petition in item number 6.
Yes, state is here. No?
Lordship.
So we have received this scan copy here.
Scan copy is received, Lordship. And
May I reconnect? I'm not able to hear your leadership. May I reconnect? It'll take a moment.
That is the reason we don't prefer for through BC. On that day also from Delhi on what I think. Same disturbance were there. The council the local council who was present there. He had to submit because there was cannot hear any.
Yes, my lord.
Please, your leadership. Let's.
Yes, you can submit.
Please. Since the foundational bedrock of my submissions stems from the FIR itself, I would like to take your lordships to the FIR once again at page 29. It starts at page 27, lords. The operative part is at page 29.
Yes.
Your lordships have it? Please, we would like to state that Mr. Rakesh Singh, son of Ram Bali Singh, a permanent resident at Sherwan, Pargaspur, Sant Ravidas Nagar, Uttar Pradesh, presently working at Dudley Tea Estate, Titabar, Jorhat, was working as a field manager at a Santop Tea Estate situated at Nazira, Sivasagar, Assam since the year 2015 and have left work making false excuses since November 2018. He, while working as a field manager, has done serious nature of misconduct, theft, misappropriation of funds, apart from many and other mischievous activities which have been lately discovered. During his employment as a field manager, he has marked false wages in the name of laborers who were not present at work at all and thereby collected huge sum of monies from the pay tables or from the laborers on mutual terms. But I'm stressing on the word or for a reason I'll come back to it. Or from the laborers on mutual terms. He also committed serious breach of trust wherein he fraudulently cheated the company several times based on his fake commitments. Now there cannot be a statement which can be more vague than this. What are these fake commitments? Nowhere specified in the complaint. Just that I made fake commitments several times and fraudulently cheated the complainant. Apart from this, he was highly negligent with his work, which resulted in huge loss of crop, approximately 1 lakh kgs of made tea, which resulted in the company suffer huge losses financially. Now, let's, on a lighter side, this is as if I'm reading a civil suit for damages. How does it make out an offense? Because only the complainant knows. It has also been discovered that the chemicals which were sent to the estate for spraying in the tea estate was being stolen under his supervision and being sold in the open market by him. Again, Millards, no foundation whatsoever. How was I stealing those chemicals? Where was I selling it? How did they get this information? Just a mere bald allegation, Millards, that I was stealing the chemicals and selling them in the open market. Now, this is a very crucial part. On being discovered that he's caught, I'll take a pause here for a moment, Liz. On being discovered that he's caught and finding no option, he left work making false excuses and thereby sent a resignation letter which was never accepted. Which is to say that when I left work, they were very well aware about this misappropriations and theft. They themselves came and on being discovered that he's caught. So why was there a delay of 6 months in registering a complaint against me? I resigned in 23rd of October 2020, 2018 minutes, and the FIR is registered in March 2019. Then let's may kindly have the FIR again. Let's the top 4 lines. Third line, in fact. Presently working at Doodle Tea Estate, Titabar, Jorhat, was working as a field manager at a Suntok Tea Estate situated at so and so, and have left work making false excuses since November 2018. So on one side you're saying that I have left work making false excuses. On the other hand, you're saying that I've sent them a resignation letter. This apart, I have my learned friend will hand over the judgments. I'm relying on 3 judgments of the Honorable Supreme Court. I'll just quickly take your lordships through them. Well, see, your lordships will first be kind enough to have Professor R.K. Vijay Sarthi judgment and versus Sudha Sithavan. Vijay Sarthi versus Sudha Sitharaman. This is 2019-16 SCC 8739. May kindly have para 17. It will be at page 9, top of page 9. May I read, Melissa?
Yes.
The condition necessary for an act to constitute an offense under section 405 of the Penal Code is that the accused was entrusted with some property or has dominion over property. The first respondent has stated that the disputed sum was transferred by the son of the appellant of his own violation to her. The complaint clearly states that the amount was transferred for the benefit of the son of the appellant and that the first respondent was to hold the amount in trust for him. The complaint alleges that the money was transferred to the appellant as per the dicta of the son of the appellant. There is, on the face of the complaint, no entrustment of the appellant with any property. Let's have the next para. The condition necessary for an act to constitute an offense under section 415 of the Penal Code is that there was dishonest inducement by the accused. The first respondent admitted that the disputed sum was transferred by the son of the appellant to a bank account on so and so. She alleges that she transferred the money belonging to the son of the appellant at his behest. No act on part of the appellant has been alleged that discloses an intention to induce the delivery of any property to the appellant by the first respondent. There is thus nothing on the face of the complaint to indicate that the appellants dishonestly induced the first respondents to deliver any property to them. cheating is an essential ingredient to an offense under Section 420 of the Penal Code. The ingredient necessary to constitute the offense of cheating is not made out from the face of the complaint subsequently. Then this is important, para 19. In Vinod Kumar versus State of Bihar, certain amounts were due and payable to a contract worker. When the amount due was not paid due to a termination of the contract, the worker filed a criminal case against the appellant for criminal breach of trust. The appellant's petition under Section 482 of the Code of Criminal Procedure for quashing was dismissed by the High Court. A two-judge bench of this court examined the ingredients of the offence and whether the complaint on its face disclosed the commission of any offence. The court quashed the criminal proceedings, holding thus: at this stage, we are only concerned with whether the averments in the complaint taken at their face value make out the ingredients of a criminal offence or not. Then with para 18, in the present case, looking at the allegation in the complaint on the face of it, we find that no allegations are made attracting the ingredients of Section 405 IPC. Likewise, there are no allegations as to cheating or the dishonest intention of the appellants in retaining the money in order to have wrongful gain to themselves or causing wrongful loss to the complainant. Accepting the bald allegations that the appellants did not make payment to the second respondent and the appellants utilized the amounts either by themselves or for some other work, there is no iota of allegation as to dishonest intention in misappropriating the property. Now, Millers, if I contrast it with our case, I'll take a moment here. If I contrast it with the present FIR, the allegations made against me are completely bald. It doesn't even mention the amount of misappropriation. They say that huge sums of money were misappropriated. In FIR, I ask myself this question, Millers: if I'm the owner of a company and I have an altercation with my employee, is it enough for me to make an allegation against him that he has stolen stationery from my office or he has stolen chemicals from my factory without any other basis or foundation whatsoever and get an FIR registered against him? It is very easy, Millers. If I am making a specific allegation of fraud against my employee, I should at least mention the amount that has been misappropriated, how it has been misappropriated. They say that when I stressed on the word or, which is to say that the complainant himself was not aware as to what amount was misappropriated and how it was misappropriated. How did he get this knowledge? It was a mere and absolute afterthought to seek personal vendetta against me because I had resigned from the TA state and joined some other TA state, that too after 6 months of my resignation. Thereafter, Millers, para 19. Even if all the allegations in the complaint taken at face value are true, in our view, the basic essential ingredients of dishonest misappropriation and cheating are missing. Criminal proceedings are not a shortcut for other remedies, since no case of criminal breach of trust or dishonest intention of inducement is made out, and the essential ingredients of Section 405 and 420 IPC are missing. The prosecution of the appellants under Section 400 is liable to be quashed. Now, let's kindly have the other judgment that I've handed over. My learned friend will hand it over to your lord, my lords. This is Lord Kishan Singh's 2010 8 SCC 775. This is specifically on delay, Millers. If your lordships would be kind enough to have para 23, Millers.
Paramjit Singh?
No, not Paramjit Singh, Kishan Singh.
Pardon?
Kishan Singh. This is Kishan Singh versus Gurpal Singh. 2010 8 SCC 775.
Acha, Kishan Singh. Acha. Yes.
Please. Let's may kindly have para 20. Rather, para 21, let's, I beg your pardon. Para 21, let's. Prompt and early reporting of the occurrence by the informant with all its vivid details gives an assurance regarding truth of its version. In case there is some delay in filing the FIR, the complainant must give explanation for the same. Undoubtedly, delay in lodging the FIR does not make the complainant's case improbable when such delay is properly explained. However, deliberate delay in lodging the complaint is always fatal. Unless there is reference to Sahib Singh versus State of Haryana in this regard, then let's kindly have para 22. In cases where there is delay in lodging a FIR, the court has to look for a plausible explanation for such delay. In absence of such an explanation, the delay may be fatal. The reason for quashing such proceedings may not be merely that the allegations were an afterthought or had given a colored version of events. In such cases, the court should carefully examine the facts before it for the reason that a frustrated litigant who failed to succeed before the civil court may initiate criminal proceedings just to harass the other side with malified intentions or the ulterior motive of wreaking vengeance on the other party. This is the teeth of my case, insofar as the submissions are concerned. Chagrined and frustrated litigants should not be permitted to give vent to their frustration by cheaply invoking the jurisdiction of the criminal court. The court proceedings ought not to be permitted to degenerate into a weapon of harassment and persecution. In such a case where an FIR is lodged clearly with a view to spite the other party because of a private and personal grudge and to enmesh the other party in long and arduous criminal proceedings, the court may take a view that it amounts to an abuse of process of the law in the facts and circumstances of the case. Nonetheless, if I draw parallel to our case and draw your lordship's attention to our facts and circumstances, I was working in this particular tea estate from 2015 to 2018. When I joined this tea estate, I was 62 years old with an unblemished record of 40 years in working as a field manager in this tea estate. Unblemished record, it's not a single allegation, no criminal antecedents, no complaint with regards to my conduct insofar as handling these tea estates were concerned. From 2018 to 2015, from my appointment to 2018, where I resigned, I was rewarded and appreciated for my work, for my efforts. It was only in 2018 where this particular conundrum took place that my wife was ailing and was facing multiple medical problems that I requested for some leaves. These leaves were not granted to me because of some commercial obligations that the owner must have. I'm not disputing that. But these leaves were not granted and I was misbehaved. Upon that misbehavior, I filed my resignation, which is admitted in the FIR itself. It is admitted in the complaint itself. I sent them a resignation letter that I do not wish to continue working here. Then, Millets, for 6 months, nothing happened. Now, Millets, may kindly have an. I beg your pardon for this, Millets, but my lords, may kindly have the FIR once more. At page 27. But the word used to describe the delay is one word, that they were discovered lately. If your lordships will have the first paragraph of the complaint, theft, misappropriation of funds, apart from many and another mischievous activities which have been lately discovered. This is at page 29. I beg your pardon. Page 29. From many and other mischievous activities which have been lately discovered, which is to say that they were discovered in 2019. And then Millard's page 30, top continuing paragraph. On being discovered that he is caught and finding no option, he left work, making false excuses and thereby sent a resignation letter which was never accepted. On being discovered that he is caught, meaning thereby the complainant himself discovered that he was caught. So why was there a delay of 6 months? So as I've explained to your lordships, and your lordship was kind enough to give me a patient hearing on the previous occasion as well, I was pursued for months to rejoin this Suntalk tea estate. The owner pursued me that you rejoin the tea estate, and I was in talks, but I refused to rejoin. Therefore, as a matter, to settle scores and as a matter of seeking personal vendetta, this FIR was lodged in March 2019. From October to March, nothing happened, Millets. Then lastly, Millets, I'll draw your lordship's attention to the third judgment, Paramjit Singh. But may kindly have para 16. allowed to have it. It is a settled law that for establishing the offense of cheating, the complainant oblique respondent number 3 was required to show that the applicants had a fraudulent or dishonest intention at the time of making a promise or representation of buying the said ruler set fitting. Such a culpable intention when the promise was made cannot be presumed but has to be supported with cogent facts. So I'll take a pause here. My stress is that the interpretation of the word cogent facts, and in my respectful submission would be, if you are saying that there was misappropriation, you should also explain how you got the knowledge of that misappropriation and the amount of misappropriation. And thereafter, when you say that there was criminal breach of trust insofar as selling those chemicals in the open market are concerned, the same principle will follow. For the facts to be cogent, it cannot be a mere allegation that, all right, you stole this from me or you misappropriated huge sums of money. That also they have not explained. What is this huge sums of money? Thereafter, such a culpable intention when the promise was made cannot be presumed but has to be supported with cogent facts. In the facts of the present case, there is a clear absence of dishonest and fraudulent intention on the part of the applicant as regards the sale and purchase agreement. We must hasten to add that there is no allegation in the first information report or the charge sheet indicating either expressly or impliedly any intentional deception or fraudulent oblique dishonest intention on the part of the applicants right from the time of making the promise or misrepresentation. Nothing has been said on what the misrepresentations were and how the appellants intentionally deceived the complainant. Respondent number 3. Mere vague allegations by the complainant that the appellants failed to provide a product of a particular specification and failed to replace the faulty machines do not satisfy the test of dishonest inducement to deliver a property or part with a valuable security as enshrined under section 420. Then may kindly have para 19. Furthermore, in the case of Inder Mohan Goswami, it was held by this court that the court must ensure that criminal prosecution is not used as an instrument of harassment or for seeking private vendetta or with an ulterior motive to pressurize the accused. It was further held by the court that it is neither possible nor desirable to lay down an inflexible rule that would govern the exercise of inherent jurisdiction. In view of the above and for the reasons stated above, we are of the firm opinion that to continue the criminal proceedings against the appellants herein would cause undue harassment to them because as observed herein above, no prima facie case for the offence under section 420 IPC is made out. So, in my respectful submission, if I may conclude, there is nothing in this FIR, at least insofar as the textual part is concerned, to show that there is a prima facie case made out. Because the allegations are bold, they are not backed with cogent facts, they are not backed. Excuse me, they are not backed by cogent facts, neither is there any foundational ground on which these offenses are purportedly supposed to be conducted. When I say supposedly purported to be conducted, what I mean is when they say that I misappropriated huge sums of money by certain pay books, they don't mention the pay books and they use the word or. That's why I stressed on the word or, Millets. They use the word or from the workers. Now, Millets, if you are aware that certain misappropriations or that I am being, for instance, if I take my example, Millets, if I have been defrauded, I must know how I got the knowledge of being defrauded. That this misappropriation has took place against me. How will I get this knowledge? There must be some certain factors, cogent facts that I must put in the complaint. Nothing is there. Therefore, let's request that this particular FIR along with the charge sheet deserves to be quashed, Millets.
Yes.
And I pray accordingly. Arrest.
But if I look into the FIR, there are two allegations are there. Firstly, Lordship, the use of the chemicals has been the chemicals has been sold in open market, and second is the misappropriation or criminal breach of trust, Lordship. The thing is that if you look into the FIR, how he has misappropriated the fund, it is there, Lordship, in the FIR itself, that he mark false wages in the name of laborers who were not present at work at all, and thereby collected huge sum of monies from the pay tables, so and so, Lordship. And regarding this, I will go to the scan copy, Lordship. And in the scan copy in the CD, what is there? Materials are there in two fronts. In the first, I want to state in the chemical, in regard to the chemicals, Lordship. It is that what is stated in the FIR and what it is stated by the complainant in the 180 statement, it is that, Lordship, he had to spread, Lordship, these chemicals for the growth of these tea leaves, Lordship. He has not done it. So according to the new, the manager, the loss has been occurred because 1 lakh rupees of 1 lakh leaves has been there, which cannot grow well. Because of that, 1 lakh has been lost. Then, Lordship, in regard to that, regarding chemical, what materials are there? The statement of the complainant is same as it was stated in the FIR. I want to state that. And in regard to the misappropriation, I will go to that point now. There are 3 to 4 witnesses are there. They have not stated about chemicals. So I will not focus on that point because they are hearsay. They have said they know, being aware of that from other people, they know from that. So I'm not focusing on that. I'm on this, Lordship, misappropriation for labor. They have stated that their head clerk used to pay them the payment on the fortnight, and they used to get them. And those people who were not present, that money would go to this person, Lordship, this present petitioner, Lordship. But he don't pay this to the tea estate, Lordship. He should pay to the return back to the tea estate, but he had not done so. And in regard to that, witnesses are there. And in regard to how much misappropriation is there, since this is an FIR, it should not be an encyclopedia, Lordship, but during investigation, pay book has been seized. And from there, it has been stated the amount, unpaid amount, and not received till date. It is there. Lordship may clearly look into this. I have flag mark. Lordship may look into the scan copy. And regarding this, I want to only state few things, Lordship. Since it is a petition for quashing, and Lordship very well know about the Fazan Lal Lordship case, the Niharika case also there. If there is a prima facie case has been established, it should not be quashed. And according to me, what I have stated, Lordship, materials are there in the CD, Lordship. So it should not be quashed, and the trial should go on, Lordship. Lordship, I have given the flag, I have also flagged it, mark, the relevant parts, Lordship.
Just a small rebuttal on this, Lodge, if I may be allowed to. Just a small rebuttal.
Yes, you can.
All the witnesses that my learned friend has referred to are employees of the complainant and are financially dependent on the complainant. The pay books that he is relying on are self-serving, unverified pay books, and the amount of misappropriation, if I may add, is 72,500. That huge sums of money that my learned friend just referred to is 72,500. If you look at the pay books, because I have also annexed the charge sheet and the pay books along with my petition. Moreover, Milic, apart from this, the chemicals, there is no testimony, no statement recorded insofar as that purported theft is concerned. There is nothing. Only this misappropriation part, Milic, 2-3 witnesses have testified against me. And those witnesses, Milic, are interested witnesses because they are financially dependent on the complainant. They are working there. They are workers there. I was the field manager. Their livelihood is dependent on the complainant. No independent witnesses there. That is my only submissions with regards to that. Order reserved. Obliged, my lord. Deeply obliged. Deeply obliged.
Highly obliged, man. Highly obliged. Please, your lordship. My lord, appeal against conviction, my lord, under section 21C and 29 of NDPS Act, my lord, passed by the special judge Karbi Anglong Difu, my lord. At this stage, my lord, appeal may be admitted.
Yes.
10 years, my lord. My lord, I'm on behalf of Motiur Rahman, my lord. I'm M. Rahman. M. Rahman, my lord. On behalf of Motiur Rahman, my lord, advocate. He's Motiur Rahman. His full name is Motiur Rahman, my lord.
State respondent. This is an appeal under section 415 of PNSS against the judgment and order of conviction dated 2011-2025 passed by learned special judge NDPS Karbi Anglong Difu in NDPS case number 54 of 2023, convicting the accused appellants. How many appellants? 2 appellants.
Yes, my lord.
Two
Two,
appellants.
my lord.
2 appellants. Convicting the accused appellants under section 21 capital C 29 NDPS Act and sentencing them to undergo RI for 10 years along with a fine of rupees 1 lakh with the stipulation. Appeal is admitted.
Lord, one IA is also there, my lord.
Appeal is admitted. You can represent both 1 and 2, I think.
Lordship.
The TCRP call for. Least you will do the needful. Least you met accordingly immediately on receipt of the TCR. I for same order, hearts and so.
Lordship, I for bail, Lordship.
IA for bail.
Yes,
So it's 10 years punishment. We'll file our objection.
Heart Mr. So and so, MS so and so deliver. This is an application under section 430 PLSS for suspension of sentence and order of conviction dated 2011-2025 in NDPS case number 54 of 2023 by learned special judge NDPS Karbi Anglong issue notice to the respondents. No formal notice is required to be served on the state respondents. However, the requisite copy of the petition may be furnished during the course of the further. It is submitted by MS Bora that state may file their written objection on receipt of immediately after receipt of the TCL. In view of this, let the matter be listed along with the criminal appeal number 113/2026 immediately after receipt of the TCL. Okay, we are listed.
Lordship, for filing objection, 6 weeks 10 may be granted.
Let it come, then you see.
Lordship.
In the meantime, the state respondents may file their written objection.
Lordship fixes any date, Lordship?
No. After immediately after receipt of the TCL, it will be.
Lordship, organized.
Obliged, Lordship.
I am pleased, your lordship. Also, I'm praying for some accommodation today, my lord. My lord, leading counsel, Mr. P.K. Munir is not well, my lord.
For respondent number 2, one Mr. M. Kalita is
Kalita.
you are appearing.
He's appearing on behalf of his.
We have received this scan copy, na?
Lordship, scan copy received.
You are Mr.
A Gayan, my lord.
Heard Mr. A. Gayan appearing on behalf of Mr. P.K. Muni, the learned counsel for the petitioner. Also heard M.S. S.H. Bora, the learned petitioner P.P. appearing on the state respondent. And Mr. M. Kalika, the learned counsel appearing for the respondent number 2. It is submitted by Mr. Gayan that due to ill health of the leading counsel of NPS counsel, Mr. Muni, matter may be adjourned. Considering the submission made by Mr. Gayan, the matter is adjourned.
My lord, there is an interim order,
After
my lord.
vacation, you want any date?
My lord, after vacation, my lord.
After vacation. Accordingly, the matter may be listed immediately after vacation as an date.
My lord, there is an interim order. Interim order may be
Interim
continued.
interim be continued.
Obliged.
Much obliged.
Timing item number 3.
Yes. Yes, we are CBI is there.
Yes. We have filed this, our objection, probably it is not on record. It has.
You
might
filed
have-
your objection.
We have filed written objection.
Which one are you, my report?
My lord.
You have received the copy?
Yes, my lord.
They have received, we have served them. We have filed yesterday only, that is,
You have filed yesterday only?
yesterday one.
My lord, I have the copy. If your lordship may.
No, it has to come. It is a petition for quashing,
Passing for of order, modification of order, bail condition
bail condition. Only modification of
of
bail
the bail
condition.
condition. I was not allowed to move throughout India without taking permission from the Planet Trial Court. And that condition was not waived even after receipt of the application.
Your
This
Lordship,
condition was not,
That condition was not modified
not verified. By whom?
by the trial court.
So what is your difficulty in taking permission?
Because I have to move around India for the, to look after my fathers and
Your father stays where?
my father stay in Bihar,
Bihar.
UP,
Ah.
sorry. And I have to go throughout India for my work. I am working in NHI.
Yes, what do you want, Miss?
oh, yes, may I please, your Lordship? What happened, your Lordship, while granting a, page number 12?
No,
Page number 28, may kindly be
we
seen.
don't have
No,
your
main
objection.
petition, main petition. Main petition.
Objection for 9. It will record on 9.
Main petition, their petition itself.
Page number 28.
We have
28.
not received your objection. He's
No,
saying that yesterday
their
only.
petition I am.
No,
Their-
no, yesterday only. We need
Yesterday
your
only
objection
we
also.
have
It is
yeah,
not on record.
But today I want to show your Lordship, their petition at page number 28.
You want to go for hearing?
As if he is pressing hard for that, that is why. Otherwise, let the objection come on record.
Objection is not on record.
Because since they are pressing hard, that is why.
At where, on which date you are proposed to go or you're supposed to go? Is there any
I
date
have-
fixed by you?
I have also filed one application that is fixed on 11th. Before
Why
the trial
you,
court.
it is
No,
not
Lordship,
considered?
what happened, only the condition is that the accused petitioner shall not leave the jurisdiction of the court until completion of further investigation, if any, without prior permission.
That is only.
No,
that is
as and
only-
when he wants to go, he filed a petition and the learned trial court has allowed.
Then
They never debar it because earlier on 2 occasions, without any permission, he has gone outside. So that is one of the reason he want to avoid the scanning of the trial court. Somehow, and he doesn't want to be in the scanner of the trial court. And earlier 2 occasions, he is a public servant, your Lordship. And without permission, he went. He simpliciter, it is one application is required to be filed and take permission. There are many accused person who are taking permission and they are going.
This type of conditions are there in many
So
cases.
this condition is not a stringent condition, Your Lordship. This is only for smooth running of the trial, Your Lordship. No stringent condition has been given. This similar type of conditions are given to many other accused person. They used to file a petition, take the permission, they give the itinerary of their program, and they can go. And earlier also in number of occasion he has been allowed. I don't know why he has come for modification. And earlier his petition is rejected by this honorable court. I have this one.
This application is not for the modification. That was
Yes.
my lord.
Reason being, why?
My lord.
Okay.
My lord, I have informed who has informed the land trial court that I myself informed the land trial court that on 2 occasions I unable to inform this on the trial court for leaving the jurisdiction of the trial court and filed an application that I have on such 2 occasions went outside the jurisdiction of this honorable court for the sufficient reason under compelling circumstances. And honorable trial court has accepted the application and by imposing a cost of rupees 1,000.
So that is why the cost has been.
I have myself informed the trial court that I have any intention that I have to escape the proceeding. I would not inform the trial court. I have especially stated in my application also in the page number 8 of this
that is
criminal petition.
addition on their part. They are bound to inform, otherwise their bail condition is there and otherwise bail will be cancelled. So under compelling circumstances, they have informed when they come to know that it has come to the knowledge of the competent authority. And that is why cost has been imposed. There is no as such impediment there. He is never debarred to go outside.
My lord, earlier occasion I have filed one IA in this case. An earlier occasion when I want to go to meet my parents, that was rejected. That was not considered by the land trial court. That's why I filed an IA before this honorable court, which was in this case IA number 180 2025, and this honorable court was pleased to allow me to go to meet my parents.
IA 180.
180 by order 63 2025.
It's not tagged with this record. 180 is not there. 180 IA के बाद से get to 9.
That was disposed of earlier years. For some reason, it was rejected. They have come here.
That was not rejected. That was no order was passed because
No
the
order was passed. That is maybe the reason. We are not on that. But earlier occasion, this happened. Then this honorable court has rejected. Again, 2,000 cost was imposed. This order will reflect the detail. In earlier occasion also. So.
For the same.
Yes, same accused person. They have earlier.
Same accused person in connection with other case or in present case?
In
present case.
In present case only. It was earlier rejected.
Earlier rejected.
Earlier I filed one modification application and the condition which was cost was imposed upon me. That order was I had challenged because I have no cost is to be imposed upon me.
Petition, what was your prayer?
Now, in this application, one prayer was that my condition was I want to go to meet my parents. That was not considered by the land trial court. That's why I filed this IA.
So this
She is speaking about another application which I filed before this honorable court.
No, this IA is only for modification of clause number 5 for taking of permission. So far, my little knowledge says, and I have come to the prayer.
No.
You want to get modification in this order?
In this application.
This application, yes. In this application.
Your application was different.
That without permission, he want to move around. He don't want to intimate the this court, competent authority. And that was the condition precedent while granting the bail.
I myself informed the
If-
trial court that on 2 occasions I unable to inform the trial court.
He is having the passport also, everything is having, just he has to inform and go.
My passport is with the trial court. I submitted my passport. I don't want to go anywhere outside India.
No, that was
And
granting.
only my investigation is yet to be completed, further investigation. Charge sheet was laid in 2022. Charge sheet was laid, part charge sheet was laid on 10/8/2022.
By the present application, what is your prayer? Because there are
My
many
prayer is that
prayers.
the condition for
No, if you
taking
go by
permission.
your prayer, there are 1, 2, 3, 3 prayers are there, including. Now,
Three prayers.
uh,
Prayer for modification was
Is also speaking with regard to the modification of the order dated 30/9/2022 and the bail condition number 5 imposed order dated 32nd.
then what is the impugn order dated 30/07/2024? What is it? Because your prayer is goes by that way also. The impugn order dated 30/07/2024. What is it?
3306.
Rejecting the prayer for modification. We have annexed that order.
Yes, ma'am. 39 to that order is page 17. Relevant page is page 28. 39 to
This,
722.
your prayer for modification was rejected.
Modification was rejected. Earlier condition was there that I should not go outside the jurisdiction of the land trial court without taking leave of the permission from the land trial court. Condition number 5, page 28. That condition was imposed.
So now you are against the order of 30/07/2024
No,
only.
my lord, that condition was a
There was no other prayer from you for modification.
modification was there.
Where?
And my
Where?
application for modification is at page 50 and exit 4.
Where is your prayer in this present case? Is there any prayer for modification? Your prayer is only for against the order of 30/07/2020.
Impung
You have not prayed for modification.
my lord. That application
what
was
to
filed
say?
by
Yes.
another advocate. My lord, I will file one application for correction.
Now what? The prayer portion you want to incorporate any prayer or what you want?
I want to prayer portion. I will.
No, I think because now your petition,
Because it should
now
be
your
order dated.
your post title also speaks in that manner only.
My
Because of
lord,
20, 30.
Also like
Ah.
that. Is it?
Your entire petition is defective. See,
my lord, I will file one.
file one I because if you want any
This
modification there,
order dated,
prayer.
it ought to have been written as 37/2024.
Yes, 37/2020. Or any para you can add those things that on 37 there was a prayer for rejection was there.
Yes.
So now by this petition you want to modification of the bill condition number 5 and all. That much only. So
Right.
better to withdraw, I think. Otherwise it will go
I
against.
will file one IA then.
I-
Otherwise, it will again take.
How I will do because cost title is defective, prayer is defective. So
It will
that
create
case,
confusion.
it
That
will
is why it
create
is
again
creating a confusion.
Immediately you file, maybe tomorrow, by the after tomorrow also. Oh, it's a holiday. Now at present, when you're supposed to go, is there any planning for you
Yes,
to
ma'am.
go? When?
Delhi.
But
No,
it's
yes,
not
Delhi.
rejected.
When?
But it was not rejected. He has not filed any application there.
When?
that part he can take permission now. Yes,
That's
so
why I just asked him because
that
filing the new one may
competent
take
court
some
is
time.
granting leave. Every time granting.
From 18/4/2026 to 26/4/2022.
18/4.
For
Then immediately
18.
do one thing. You you better to withdraw this one and file one new one for modification. It's okay. And another one, if you want to go to Delhi on 18th itself, so immediately by tomorrow or by day after tomorrow, you make an application before you learn it.
Yes,
Yes.
first they will have
I
to
have already
approach.
filed an application.
Pardon?
First they will have to approach them.
No, yes. No, I'm not on that. I'm just saying that we are concerned with the modification of the order. We are not concerned with the permission. So if you want any permission, you immediately file an application before the concerned court, or you can withdraw this one today. Because what I'm saying, because next for filing of the another petition, it may take some time, and from tomorrow, from day after tomorrow onwards, it's a holiday. So that's why I'm just asking. You
My
can
lord,
approach.
thank you. See the prayer number 1. The impound order of 37. 37 was chale. 37 order was for modification, which was rejected. My prayer is that the impound order is 37 2024. That is the modification order which was not modified. There is a alright, madam.
Yes, in that regard, do you want to submit anything? He's saying that he is challenging 37.
37.
37, so far I know, it is an application which they have filed in the said court for modification, which was rejected. So against that they have come before this honorable court to modify the order dated 39/22. That is the bail application in which condition 5 was imposed.
My lord,
So two date is reflecting here. Two date. By 39/2022, one condition has been given. So to modify that condition, they have approached the trial court for modification, and that was rejected by the order dated 37/20. And that is why
they have
approached
come before this court
this
on
honorable.
37 only. We can dispose of that.
37.
37.
And 37 is annexed here. 37 order is, yes, annexed here with, and it is a very reasoned order. It has been given here, 37. That is at page number 65. I am of the view that the condition number 5 is an important condition which was imposed at the time of granting bail. It is also to be noted here that further investigation of this case is still going on. It is not the case that the accused petitioner has been at all debarred from leaving jurisdiction of this court, but the only criteria is that before leaving jurisdiction of this court, he has to obtain prior permission of this court. Therefore, I am of the view that the condition imposed is required to be kept as it is. As such, prayer for modification of the said condition as prayed is liable to be rejected. And prior to that, a reasoned order has been given here. It is a number of pages are there. Reasoned order is there. Why this has been not modified? To let my objection come, and then honorable court can pass.
No, we can dispose of the matter today. By today itself, we can dispose of the matter.
As your lordship. So my concern is that if this condition will be avoided, he will be free to move, because this condition is the condition precedent of the bail.
In their objection, they have only stated about the condition which I have highlighted earlier 2 occasions. Nothing new is there.
But Mr. Arkin did on it for repetition. I'm quite in understanding also. This is an application. Section 528 BNS.
May I apprise your lordship? Otherwise, another accused has filed a petition, and in view of the filing of that petition, the trial court proceeding has been stayed. So thereby, if all these things will go, the total matter will get diluted
Why proceeding is stayed means?
by other accused person. Some infra who is involved in this conspiracy. He is the public servant, he is the contract. So everything is getting diluted there.
My lord, I will,
That is the very intense.
my lord,
Okay, then we will record your submission. That Section 528 BNSS, review section 483 BNSS, for setting aside the order dated 30/07/2024, passed by learned special judge CBI, whereby prayer for modification of bail condition imposed by order dated 30/09/2022 in special case CBI number 05/2020, arising out of FIR number RC 2162022 capital A 0007 dated 12/06. It is submitted by Mr. Moore that while passing the bail order dated 30/09/2022, the learned special judge CBI number 2 had imposed bail condition.
5 conditions.
The imposed 5 numbers of bail
That is
condition.
at page number 42 of their petition. Your its order is from, it starts from 35. 35.
No, it's
Like-
page 28.
Page 28. Page,
Yes, 20.
page 20. Page 20. Page 20. Order starts from page 17.
Yes, I have seen. Imposing 5 bail conditions, and out of which the bail condition number Roman 5 Divo and a Caribus invert comma Divo, that the accused of the petitioner shall not leave the jurisdiction of this court until completion of further investigation, if any, without prior permission of this court. Next. Mr. Moore accordingly submitted that he had to visit all over India for his official purpose, and that apart his old ailing father resides in Bihar, and for which he had to visit frequently to the other states of the country as well as state of Bihar for his old ailing father. But every occasion it has to be make a prayer before the learned special judge for permission to leave the jurisdiction, and in some occasion even after the urgency, he had to move an application before. However, he submitted that in every occasion he took prior permission and left the jurisdiction of this court into the jurisdiction of the court. But in two occasion, due to some urgent situation, he had to leave the jurisdiction of this court without making any prayer for permission, and thereafter he already informed the learned trial court below, and his prayer was allowed with a cost of rupees 200. He the such nature of bail condition as imposed on the present petitioner is arbitrary and the also violates the right of the present petitioner guaranteed under Article 21 of the Indian Constitution. More so, the petitioner being an employee of National Highway Authority of India, he is required to travel frequently to nearby districts of Assam, including River of Meghalaya for his professional exigencies but it is difficult on the part of the petitioner to take permission of the court on each and every occasion, for which only he filed an application before the learned special judge, praying for modification of the bail condition number 5 as stated above, but by order dated 30/07/2024, the learned special judge had rejected the prayer for modification of the bail condition number 5 and had rejected the prayer of modification which was imposed by order dated 30/09/2022, while the bail order was passed for the present petition. Accordingly, Mr. Moore submitted that this present petition is filed for setting aside and quashing of the order dated 30/07/2024 passed by the learned special judge CBI in Miss case number 6 of the 2024 arising out of special case number 5 of the 2022 dated 30/07/24. However, he is ready to abide by all other conditions imposed by the learned special judge, and in view of such condition, he has already deposited his passport and other documents as required under the bail condition. Next paragraph. MS Kumari, the learned standing counsel CBI, submitted this report that 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 he was never debarred from visiting other places of the country with prior permission of the court, and every time and in every occasion his prayer was allowed by the learned trial court below. However, in 2 occasions, without informing the court and without taking any prior permission, he left the place of jurisdiction, and when the authority concerned had came to know about the situation, then only the petitioner informed the learned trial court below, and on which the prayer was allowed with a cost of rupees 1,000 to the present petition. The case is still under investigation, and there cannot be any there cannot be any submitted that the learned trial court learned trial court below learned special judge had passed a well-reasoned order while rejecting the prayer for modification of the condition number 5 and condition number 5, and hence there may not be any reason for any interference in the said condition of the court, in the order passed by the learned trial. Further, she submitted that this is the bail condition is also not not a stringent condition, and in many matters, this such kind of condition had to be put by the court because of the to procure the attendance of the accused persons or for cooperation in the investigation of this case. She further submitted that it is they submitted that cases of very serious offense against serious offense of corruption is 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 pending before the special judge, which affects the entire economy of the entire country, and hence the modification of the order, modification of the bail condition number 5 is an important condition, and hence it should not be modified at this stage. Accordingly, she submitted that the learned special judge had passed a well-reasoned order, and there is no reason to make any interference in the order passed by the learned trial by learned special judge. Next, hearing this submission made by the also peruse the record and the orders passed by the learned special judge while granting bail dated 30/09/2022, as well as the order passed by the learned special judge while rejecting the prayer for modification, that is 30/07/2024. It is the case of the petitioner that he needs the modification of the order, modification of the bail condition number 5, by which he was to take prior permission for leaving the jurisdiction of this court. But as he, being a employee of National Highway Authority, had to visit frequently outside the states of Assam or the nearing states of Assam, and that apart, he had to attend his whole alien pet who resides in Bihar. But besides, on the other hand, it is the case of the CBI respondent that the such nature of condition is necessary for the further investigation of this case, as the accused petitioner is investigation of the case. More so, he was never debarred from leaving the jurisdiction of this court, and on every occasion, the prior permission was given by the court whenever it was applied. The next paragraph, the order dated 30/07/2024 is basically observed by the learned trial court, learned special judge. Find that the condition number 5 imposed on the present petitioner is an important condition which was passed at the time of granting bail, and it is also observed that the investigation is still under process, and if the petitioner and also observed that the petitioner was never debarred from leaving the jurisdiction of this court with prior permission. Accordingly, it was held that the modification of such condition is not necessary, and the same was rejected. it is seen that from the order passed by the learned trial court below, as well as from the submission made by the Standing Council CBI, that in spite of the said bail condition, the accused petitioner was never debarred from leaving the jurisdiction of this court, and in every occasion, the prayer for prior permission was allowed by the court without uh, without any without any very good, and there was no such occasion wherein the prayer for prior permission was rejected by the learned trial court. However, it is seen that in two occasions he left the jurisdiction of this court without prior permission. The court, and on coming to know about the same, he, by the authority concerned, he was compelled to file information before the learned trial court below, which was accordingly allowed at a cost of fees. Thus, it is seen that the condition which was imposed under the bail order dated 30/09/2022 cannot be considered as a stringent condition, and it cannot also be held that it cannot be abided by the petitioner. The court was the learned trial court below is also seems to be liberal while granting permission to the present accused petitioner whenever any petition for permission was applied, and it was considered liberally, and the prior permission for leaving his jurisdiction was accordingly considered by the learned trial. Considering the entire facts and circumstances of this case, it is seen that the bail condition which is imposed at the time of granting bail condition number 5, which was imposed at the time of granting bail, should not be interfered at this stage, as the part of the investigation is still going on, and in which occasion the presence of the petitioner may also be required for the purpose of investigation as well as trial. Further, it is submitted by MS Kumari that one of the petitioners filed an application, and on the basis of which the further proceeding is stayed in the learned trial court below, and for which, if such nature of application is allowed, it may also hamper the further trial of the learned trial. Considering the above aspects of the case, this court is of opinion that there is no need of any interference in the order dated 30/07/2024 passed by learned special judge number 10 in case of switch. Hence, the present petition stands dismissed. Your petition stands dismissed. However, the petitioner is at liberty to approach the learned trial court below, as and when there is any requirement to leave the jurisdiction of this court, and in that case, the learned trial court, learned special judge may consider his application for permission.
Okay, deeply open.
He was
Lordship, before my learned friend started, Lordship, here is a second petitioner is also there, respondent number 2, but notice had not been issued on earlier occasion. 31. In item 31, and in item 32, though service awaited, Lordship.
No, notice served. Only information is not served.
No, condonation awaited leave.
Is it a contradiction? No.
32. In 31, Lordship, someone has not been issued. Sorry, Lordship, to respondent number 2, notice had not been issued. In
In
item
31.
In 31.
In 31.
31.
I mean 32. And notice issue respondent number
31 কিন্তু দিয়া নাই মত নাই
কন্ডোনেশনও দিয়া গৈছে তো
31 নাই দেখো
কন্ডোনেশন নোটিস স্যার you see the record my lord
In the office
notice
note,
served my lord they have
maybe
not
look into
come
that.
here.
In the office note, it may be looked into.
I don't
Because
know what is
since it
there
is
in the
the-
office note but notice was served
In Condonesia.
Main যদি দিয়াই নাই আপোনালোকে মেইনটোতো দিব লাগিব না
Main, in the appeal, you have not issued notice.
not issued lot.
What is the case in fact? Because sometimes it happens that
It 376 lordship 8 years
is-
punishment is there, and they have also made the party lordship. Respondent number 2 is also there.
sometimes it happens, Mr. Day, that what we do, sometimes notice even suppose even it not served or served, and in absence of this, generally we condone the delay because it's a criminal appeal. So we don't bother for any appearance of the respondent number 2. But while after admitting the appeal or after registering the appeal, you have
I shall sir
you
I shall take step my lord. I shall take step
that's not been done. I think.
my lord I shall take step my lord
Better to take step in that
today
case.
it has come up for bail my lord he is in jail for 2.5 years
Bail
already
is important. In her absence, it cannot be. In her absence, it cannot be heard. Now, since when he is in jail?
my lord since the judgment my lord, 2024 19/3/2024
24.
he is in jail yes
Then more than
More
1 year.
2 years and earlier it is 6 months during trial
So 2.5 years.
2.5 years my lord. My lord, other
we
two other two
in the
other two accused has been granted bail
I don't know. Maybe. I
They are also not it.
you have not filed your objection also, na?
It is 8 years lordship, below 10 years.
Acha, below 10.
and for the judgment
So
my lord,
in I also she is not appearing.
not appeal
No issue, notice not issued. No. Actually,
Okay, then I argue that it
and
will-
from the judgment my lord, your lordship I shall satisfy my lord that there is my lord, I have made it in the appeal my lord your lordship will certainly my lord
maybe there may be reason.
My lord.
I won't disagree with you, but appeal is admitted on the last occasion on Mr. KKD Act 31. The it has done it from the that notice is issued on the respondent number 2. So she made party to the instance. In that context, Mr. Day submitted that while condoning the delay, the notice was issued. The respondent that they sent that of the appeal after registration of the appeal, no notice is served on the respondent. In view of this, that notice be issued to the respondent number 2. That process is required here? No, I think. Through your office, it is not required.
in these cases, are not required. Lord.
To
In
speed
POCSO
post-
cases, only it is there.
to speed post and usual process. You can also send to your jurisdictional police station.
Not required.
Also send to the jurisdictional police station of the respondent number. This year we have received.
LCR has come
This year has already been received. List the matter accordingly. You want any fix it here?
my lord kindly fix up a date my lord
will do.
তাৰ আগত নাই নেকি ইমান 1.5 মাহ হৈ যাব এপ্ৰিলৰ লাষ্টৰ ফালে দিব নোৱাৰে নেকি
No, no. Oh, we don't have any. It's 14th of April for or did I do this? I do things. Your petitioner is in
My lord, my case, my lord, already admitted and my state and bail granted to me, my lord. And my lord,
so you are outside.
await for respondent number 2 service.
Service is awaited.
Yes.
32 Diba had Mr. P.K. Ilan counsel for the appellant, also had Mr. K.K. Das, Ilan additional PP appearing on behalf of PCR has already been received, appeal is admitted. However, uh, the notice on the service on the respondent number 2 is still available. List matter record
Come up along with this matter.
along with criminal appeal number 385 of 2025 on 14/5.
Deep progress.
Yes, what is 33?
May it please your lordship. Your lordship, as per office note dated 4 April 2026, the fresh steps for notice upon respondent number 2 has been completed. However, neither the AD card nor the unserviced notice has been received back yet.
Let it be awaited till next day. In that case, we'll pass other order if it is not. You are Mr.
I.S. Mazarbuya, appearing on behalf of Petitioner Counsel N.H. Mazarbuya.
I.H.
I.S. Your Lordship.
I.S. Madhavi, hearing on behalf of Mr. M.H. Madhavi. Also heard M.S. Sechwara, the Dana Petitioner PP, appearing on behalf of state. As per office note dated 4/4/2026, the service is still awaited for the respondent number 2. Let the service be awaited till next date of this. List the matter accordingly. Immediately after vacation, we'll do.
Lordship.
Immediately after vacation.
Okay.
We cannot provide any date.
Lordship.
Will do. We are listing it. Your interim was there. You are not
Yes,
aware of.
yes, Your Lordship.
No, not interim. Interim
No
may be
interim, Lordship.
considered, not interim. Sorry, no interim. Can I fix it? Okay, we are fixing a date.
Okay.
1/3 of May.
Obliged, Your Lord.
Oh.
May please, lordship.
It's not served yet till date.
Lordship, as per the last order dated 8/1/2026, Lordship, I was directed to take steps for service of notice through the concerned police stations. Lordship,
Yes.
I've taken the steps, but I've gone through the records, but no service report has come up today, Lordship. Till date.
Is there any office note in that? 6/1/9. There are office notice of 6/1/2023.
Yes.
Thereafter, is there any office note?
There is no office note thereof. As per office note,
On,
it is
now see, on 8/1/2026 also one order was passed.
yes, Lordship.
So in that case, before trial court, could you, is there any successful? No.
No, Lordship, because actually the one who's representing there, they will have to file another wakalatnama because this is a completely separate case, and what I heard is that even the clients were reluctant to engage them as the counsel in this case, actually.
No, but your case, which the present case
Yes.
is also pending before the trial court.
Yes, before trial
Now
court.
the
That
accused
is
is
for
not
trial.
represented by anyone there.
They are represented there, but this
That's how I just asked you to
yes
service a notice
yes I have
through the council.
I have contacted them, Lordship, but
Ah.
they were reluctant to accept that notice, Lordship. because
In one hand, they're appealing for the accused, then why are they reluctant?
because this is another case, Lordship, filed for cancellation of their bail, Lordship. So
Another case,
they'll
means what I'm saying that
Yes.
as you are representing the accused
Exactly.
in that case,
Yes.
in original case or the trial
Yes,
court,
yes,
that very well you can represent this one also.
there is some issue
Tell me
regarding.
one thing also, Mr. Brook, that the question I want to ask you that you are for cancellation of bail.
Yes, Lordship.
Now, stage of the case at present, what is the stage of the
It
case?
is at the stage of evidence, Lordship.
Is there any evidence recorded?
Yes, 3 witnesses have been recorded till now. What happened is that, Lordship, this case was pending. This case was pending before the additional session judge number 3. But the case is that it was lying vacant for many months. Now this case has been transferred before the additional session judge 4, and the case is pending there for evidence now. Because at the court of additional session judge, another case is specifically being taken up, which your lordship may be aware of. So because of that, lordship, now that case has been transferred to additional session judge 4, and it was being handled by senior standing counsel Mr. M.K. Boro, lordship. But Mr. M.K. Boro, he recently got appointed as the public prosecutor, lordship. So he resigned from the DRI. Now the stage is that this case is being taken up by me from today, lordship. So I'll get some new instructions from the department as to what stage is there at present with this
See,
case.
this is obviously this is a case of for this cancellation of bail.
Cancellation of bail.
But it is abiding by all the conditions. Suppose I'm just otherwise.
Lordship, we are not there actually, lordship. We are just on the merits of that of the bail order, lordship.
Yes, so
Yes,
when
other
the-
side
at the
has to
time
be.
of granting bail,
Yes, we are
some
only on the
sort of
merits.
things are there.
Yes. Otherwise, they they're required to be heard, lordship, before passing any order, because this is for cancellation of bail.
Yeah, that's what.
Yes.
So now what to do? Awaiting or what to do? We can.
Lordship, as per the office note, lordship.
Office note is of 8-1. That's
Yes,
what I'm saying.
8-1.
There are
Respondent
no office
number
note is
2
there.
is served.
Let them file, prepare one note. We'll pass the order accordingly.
Yes, lordship.
The office is to inquire about things and will give a note in that regard.
Yes.
So as per you, when you have taken steps through jurisdiction police station?
On 19/2/2026, lordship.
19/2, no?
Yeah.
Mr. K. Brook, the Learned Standing Counsel for DRI. DRI, full stop, is submitted by Mr. Brook that in person to order dated 8/1/2026, they have already taken steps to step for issuing a notice to the then respondent accused through jurisdiction police station. But it is seen that there is no office note to that regard as to whether any notice has been served to the respondent number 2, which was sent through jurisdiction police station. In view of this, the registry is hereby directed to make an inquiry in regards to service of notice on respondent number 2. Respondent number 2, which was sent through jurisdiction police station, and also to inquire. Earlier, you have sent through your speed post, I think.
Yes, post.
And also to inquire about the service of notice, which was sent earlier through speed post oblique registered in. Mr. Brook further submitted that though he made an attempt to serve the notice to engage counsel of the accused respondent number 2, but the learned engaged counsel had refused to accept, showed his reluctancy to accept the notice as it is a new case where it prayer for cancellation of bail. Is the matter accordingly 11th of May will do?
Yes, court.
11th.
Deeply
If you
appreciate.
get the chance of this, now Mr. Boro is not there.
Yes.
So if you get the chance of appearing before the trial court for this case, for the
Yes,
other
yes.
side, for the state or the CPI, sorry, DRI,
In that case, you may make an, have
Yes,
an
I'll
opportunity
try
of
to
contact.
speak to them personally. Otherwise, Lordship, if in next date an amicus can be appointed for them, Lord. Because
See, here to personal presence is required because it is a cancellation of bail.
yes,
Amicus may not have such kind of information with him regarding those things. If we don't find any alternative, in that case, maybe. But otherwise, I don't think it is maybe a proper stage to it.
yes, Lordship. Deeply obliged.
Even service report,
Service is still awaited.
Lordship.
for 3 weeks, that may be because it's not worrying.
From the it's not dated 4/4/2023. It is seen that the service is still awaited for the respondent number 2. Let the service be awaited till next listing. 3 weeks, after 3 weeks, I did it. 15 of. Under which process you have taken steps?
15 in register
Speed post. To speed post.
in new address, my lord. There is the new address.
Okay, we'll
But last-
ask the registry also.
Madam.
In the meantime, the registry will also inquire about the service of notice on respondent.
Madam.
Even-
Deeply obliged.
6.
Please, Lordship. The service is completed, Lordship.
Service is complete.
Completed.
It was sole respondent.
Sole respondent. The Lordship, the prayer is to vacate the ex parte order only.
You are Mr.
SRA Nasir.
Hard Mr. S.A. Nasir, the learned counsel for the petitioner. Office note dated 4/4/2026 reveals that service is completed on the sole respondent, and it is seen that notice is received by the brother of the respondent by putting his signature in presence of the witnesses. In view of this, it can be the service may be service be deemed to be completed on respondent number on the sole respondent. We need here any record? No.
Already recorded.
Record is already,
already recorded.
record has already been received. Registry is hereby directed to list the matter in the admission column on next date of listing. List, yes, they did think about it. 14th of May.
14th of May.
Yes.
Lordship. Deeply obliged.
Before my learned friend started, Lordship, I want to state here that in my petition, it is stated that the case was fixed on 23/4. CD was called, but it has come prepared. So I don't have the CD, Lordship. Case was fixed on
No,
23/4.
one IA has been filed.
Okay, I is also there.
They have filed one IA.
Lordship, if I may just
Certain development, yes, you have
a brief
already filed.
We had filed this EB earlier. That time, no FI was registered against me. And on the first day itself, the court was pleased to grant us interim protection. Thereafter, the report was called for. Meanwhile, the FI was registered against me. That's why I filed this connected IA 314 of 2026, praying for to bring on record the subsequent developments, as
Okay,
well
then
as
they
to
can
also
be tagged with you. Otherwise, when the date is fixed?
23 April, Your Lordship.
Okay, then. You are on interim?
Yes, Your Lordship. Even otherwise, Your Lordship, this petition has largely become infructuous because in the main petition, Your Lordship has given us interim protection.
But I want
So
to.
nevertheless, it may be taken up.
But
the next
I want to state here, Lordship, in this case, here there no coercive action is given when the FIR was not registered. But now the case has been registered under 103, Lordship, murder case. And the causing of disappearance is also there, 228. It is also there, Lordship. So it is much grievous now.
Okay, then no issue. It has
I-
already been fixed on
that is why
23rd.
CD has been called for, Your
CD
Lordship.
be called for, Lordship.
CD already called for, no?
Already called for.
Yes, Your
So,
Lordship.
we can
CD and
ver-
PM report is already called.
Yes, it's okay, no issue.
Mhm.
No, but this IA, we won't pass any such kind of
No,
order. We
no.
bring onto the record only.
Lordship,
That
on record.
much.
Lordship.
IA. Your name is not here?
M Shah for SC.
M. Shah. No? Card Mr. M. Shah, Lieutenant Counsel appearing on behalf of Mr. S.C. for the applicant and also card Mr. K.K. Das, Lieutenant Additional Police. This interlocutory application has been required only to bring certain record and the subsequent development up pursuant to filing of AB 415. Let the present I be kept along with the case record of AB 415/2026 as a part of the record, to which Mr. Das will run a decision if there is no objection. In view of which the IA stands disposed of, let the I be kept along with the AB 415/2010. Is there any prayer in I?
Actually, your lordship, earlier two FIRs was registered, so lordship was pleased to grant us interim protection.
Why you are doing these things?
That's why your lordship, you are not pressing this.
Huh?
Already now in the main anticipatory application, lordship has been pleased to grant us interim protection even to the extent of the new FI which is
Then
registered
why
against.
are you saying this? They don't do.
That's why we are.
Don't do these things to mislead the court.
That's
On
why
good faith, we passed many orders. Huh? Why are you pressing this? We are simply your application to bring some records or some development.
That was stated on the last date.
Says the otherwise. Why?
No, your lordship, it is written in the cost letter also.
Okay, list the IA along with AB 415/2026 on 23rd April it is listed.
23rd April. Lordship.
23rd April so and so. Don't try to mislead the court. Huh? Don't try.
Beg
On
your
one
apology.
hand, you are saying that in I, this is only certain development you're required to keep some record. In the other hand, on the last part of the prayer,
Your lordship,
you
in the, I
incorporated
beg your pardon,
such
the-
kind of prayer. Why?
in
Why
the
that
cost
is
letter,
there?
it is written for modification also,
That is,
lordship.
what modification? What modification you need? You say file this IA only to bring some records in the some development or some records in the matters in the record. Some relevant documents may be there.
Yes,
In
sir.
the last part of the you're saying don't play such kind of tactics with the court.
Beg your apology, lordship. Okay.
What is your
My
I?
lord, may I please, lordship? My lord, in this case, my lord,
You are not going to hear any matter. What is the I?
my lord, my lord, one order has been passed by the learned trial court, my lord. Against that order, my lord, I have filed this IA in the pending criminal revision petition, my lord. While this
Criminal revision petition is already pending.
pending,
Is there any stay operating?
no, my lord.
Then
Then, my lord, here, my lord, some, my lord, wrong order has been passed, my lord. Therefore, my lord, calculation.
Who passed the wrong order?
My trial court, my lord.
Then that
Another
part
order has been
you
passed.
have filed your revision.
Yeah, no, my lord. New order, another order passed, my lord.
My lord, we have not received the interlocutory application. So therefore, my lord, I
Furnish it,
direct them
written.
to furnish the copy.
Misleading court বিলাকত কাম কৰি
Page 25, my lord, a new order has been
কৰা
passed.
দিগদাৰ। Heard Mr. A.M. Borpuya, the learned counsel.
My lord, may I pray, my lord, if my learned
And
friend, my lord,
also
agrees, my lord.
You are Mr.
A.K. Hannan.
A.K. Hannan, the learned counsel, agreeing for the respondent. It is submitted by Mr. Hannan that they have not received the copy of the present interlocutory application which has been filed by the applicant. In that view, Mr. Borpuya, the petitioner is hereby directed to furnish the copy of the same to the respondent side during the course of the day. Matter will be listed along with criminal revision petition number 45 of 2026 when it can.
After vacation.
After 3 weeks.
No, my lord, that is over, my lord.
After 4 weeks.
No, no. That 4 weeks long back, my lord.
Yes.
Order I have annexed, my lord. It is page 24, my lord. Order is there.
1-3.
Highly authorized.
13, my lord.
1-3. 13th of May. April, we don't have any date.
My lord, kindly, my lord, this, my lord, new matter, my lord, we.
What new matter?
For stay, my lord, I paid.
13th of May.
Highly authorized.
Apply, my lord.
This interlocutory application is filed for, my lord, correction of a, I would not say typographical error, but there is an omission, my lord, of the word, my lord, fine. In fact, your lordship permitted me to approach the appellate court, filing an application seeking 20% of the fine, because the trial court had imposed fine, my lord. And in para 3 and 5, my lord, the word compensation has appeared. So your lordship will simply say, wherever, my lord, in para 3 and 5, the word compensation appears, it should be read as fine. Only that much, my lord. Because the trial court judgment is in respect of fine. And 148 says, my lord, fine obliques, my lord, the compensation. Your lordship has also recorded in para 2, my lord, that it is in respect of compensation or fine. Page 10, my lord. Without following the mandatory requirement of section 148 of the NI Act, which prescribes for deposition of at least 20% of compensation or fine. Your lordship is recorded in para 10.
Now, why you need the word fine?
Fine. In fact, my lord, now, since, my lord, the judgment is in respect of fine, judgment is in respect of fine. 5 lakhs fine on the accused person. So I have filed the application for 20% on the fine. Now the opposite party has raised the, my lord, issue that the High Court has directed 20% on the compensation in the order. And therefore now this, my lord, they are trying to raise this issue. Whether, and the trial court also, my lord, appellate court also has verbally, my lord, asked the, my lord, counsel for the, my lord, petitioner to satisfy whether in terms of the High Court's order, you will be entitled to 20% of the fine. Because your lordship has indicated in para 3 and 5, 20% of the compensation. Now, unnecessary issue has been raised by the other side, my lord. My lord, am I clear, my lord?
No.
Your lordship has stated, para 5, my lord, if your lordship comes, my lord, to para 5, the petitioner is at liberty to file fresh application for seeking 20% of the compensation. In fact, my lord, trial court has, my lord, imposed fine on the, my lord, accused my lord, respondent. And since, my lord, the order reflects that, my lord, I have to file an application, 20% of the compensation, the word fine is missing. Now, my lord, the plea is raised by the other side that the High Court did not say that it's fine. High Court say it's compensation. And the appellate court also has, my lord, asked me to satisfy on the next date, that is 20th April, whether, my lord, I am entitled to in terms of the High Court's order. Unnecessary, my lord, issue has been created by the 148(1) is very clear, my lord, fine or compensation, whichever is applicable.
So what is your problem?
Well, I have no problem. Otherwise, with the order, I have no problem at all. Pursuant to lordship direction, I filed the application.
The trial court order, it was fine.
It was fine. If your lordship sees from the record, trial court's order in my criminal petition, my lord. Perhaps the record is there. Criminal petition 264, my lord. The other side is raising the issue, my lord. In my criminal petition, my lord, 264/26, if your lordship comes to, my lord, page 23, internal page 16, my lord, running page 23. Last part, your lordship will see, she is punished with a fine of rupees 5 lakhs in default to undergo for 1 year. So fine, my lord, imposed by the trial court. And in terms of 148, either fine or compensation. Your lordship has said, my lord, claim 20%, but it has appeared as compensation. Otherwise, I don't have the problem. I filed the application also, my lord. Now, this issue has propped up, my lord, on the part of the other side, saying that High Court has directed 20% on the compensation, not on the fine. Unnecessary, my lord, the confusion is created. Therefore, my lord, I am asking, my lord, for the correction, my lord, that it should be compensation / fine in terms of 48, or whatever your lordship says, my lord, that this compensation should be read as fine, or it should be read as compensation / fine in terms of 148. I have no problem, my lord.
Now see if it is, suppose any
I understand, my lord.
think that any calculation or suppose the
I understand.
typographic
I
errors, these
understand,
things are
madam.
there.
Yes.
But here you're bringing that fine compensation question is there.
No,
I
no.
can understand your submission.
Yes, correct, my lord.
That the order was passed as fine, not as a compensation.
That is why, my lord.
Not as a
Correct, correct,
compensation.
correct, correct.
No, but now the question is, as the matter has
Absolutely, I
already been raised
understand.
before the, so you have to issue notice. Otherwise, this prayer cannot be modified.
No, because your lordship will see, my lord, this is an order. This is, my lord, in fact, an application where, my lord, I did not press. Your lordship will kindly
Yes,
see.
yes, I know. You
Yes,
did not press.
because other side was not heard. This was closed. Without hearing the other side, this was closed, my lord.
Now
Para
matter,
three makes it
matter
clear.
has already been raised before the learned appellate court regarding the
No,
fine
your
and compensation.
yes, lordship is correct. Your lordship will see para
Yes,
page
we are not passing.
in the order of the, my lord, appellate court. There is no, my
It
lord, order.
seems that it is simply a petition for modification or correction.
My lord.
But if you go by the record, as your from your submission also, the learned appellate authority court also raised this issue, as well as the other side, because it is fine or compensation matter is there. I can understand. I can issue your the outrightly it can be allowed.
Yes.
But now the question is that this question has already been raised.
Yes.
So let them that much.
My lord, I leave it to lordship. But here, my lord, what I'm trying to say, because this is the mandate of law, because I'm not trying to bring any new facts into it. 148 is the mandate.
You are not bringing any new facts, and
Yes.
the section itself there is a compensation or fine.
Yes.
I can understand very well, no issue on that.
Yes.
And he has submitted that the learned trial court order, it was fine, not the compensation.
Yes.
So you want to incorporate the word fine
My lord,
in
correct.
place of compensation.
Yes,
That
yes.
is okay.
Yes.
But now the matter has already been raised before the learned appellate court.
Correct.
That court had passed the order of not for fine but for compensation.
Yes, yes,
But
correct.
it was
correct.
very thing for the appellate authority also, because fine and compensation, it may be for compensation or it may be fine for fine.
Yes.
But as it is only for fine, the appellate authority also raised this issue. Where the next date is fixed on your court?
My lord, that from the order it appears at 20th April, 20 April. Page, my lord, last page, page 11. That appellate court's
April.
order. Appellate court's order. Your lordship will see in the missed case, my lord.
Page number?
Page number 11, my lord. Last page. Oh, sorry, my lord, 12. 11, 12, my lord, 12. Order dated 26/3/26. Last paragraph 4, fixed 24/26 for objection. But appellate court has, my lord, in fact, stated nothing in respect of this, my lord, particular. Has made no observation at all. Only, my lord, in my application, the objection is sought for from the other side. This is a genuine
Now
prayer, my lord.
it will create another problem for you in that case. So let it be very fine. I mean,
Yes, if
and
your
in
lordship
that
has,
case, so
yes,
it goes
I
like
understand
this.
your lordship's predicament.
Because you have placed your order and you have
Yes, correct.
filed a press application. Order has already
So in
been
that case,
placed.
can I do like this, my lord? That will again, my lord, delay the matter. I withdraw this. On 28th April, my lord, I'll make my submission. In that case, if I feel aggrieved, then I can approach your lordship again, my lord.
That can be done.
Because,
Otherwise,
yes,
in that
I
case,
understand your lordship's
there are
predicament.
some
Yes, yes, yes.
technical-
Because this order has been already placed there.
Yes, already
Yes,
been
correct,
placed.
correct.
So in that case,
Yes, I
and
think that would be
order
proper.
has been placed, and you have genuinely submitted that in that issue. The other side also raised objection, but it is not for fine but for compensation.
Yes, yes.
That issue has already
Correct,
been
correct.
raised.
Because this is
Otherwise, this is very simple matter.
I
can
understand. I
dispose of the
understand.
matter
Correct,
today
correct.
itself. So that much
Correct.
only. Yes.
Yes. If
Hard
on
is
this ground, if the my lord, appellate court rejects my application, I'll approach your lord.
Definitely.
Yes.
Hard, Mr. SK Talukder, the Learned Counsel for the applicant. However, during the deliberation of it is submitted by Mr. Talukder.
My lord, can it be this way? Your lordship will record my submission that 148 mandate is in respect of both compensation and fine.
No, you're going to withdraw this one.
Now I'm withdrawing it because that will perhaps help me. And your lordship will also say that without hearing the other side, your lordship has, my lord, is reluctant to consider this application. So that part, if your lordship makes a
Then
observation.
in this case, it will be disposed of on merit too.
No, my lord, lordship will record my submission.
That will not do serve your purpose.
And
In
your
that
lordship
case,
will say, my lord, that I'm withdrawing it only to expedite the matter. I'll make my submissions there. Perhaps that will, my lord, help me, my lord.
due to some technical reason only, can this will
Correct.
help you.
I leave it to your lordship.
So also it is submitted by Mr. Talukder that due to some technical reason he wants to withdraw the same with a liberty to file a fresh. Liberty to file a fresh to know. You will be at liberty. I don't think liberty will be
That
required.
will
at this
give a
stage.
fresh cause of action because I have to file that order. If it is rejected,
Not to most probably better simple withdrawal will
Mile,
do. Na?
mile. At this stage, I'm not pressing it.
Yes. This is not pressing this one. Technical kiwa how can I do? Technical fair is allowed. In the event you just file an application, in the event if it is rejected, you come before this court, but that will be the
Correct.
reason. Or if you can convince the appellate authority that
Yes.
that may be simply reason, so
Yes.
let us.
My lord. I'm obliged.
I was saying. কি কয় হে? মই এতিয়া উঠি পাইছো।
May I please, Your Lordship? My lord, this is a application for extension of time, Your Lordship. My lord, this honorable court passed an interim order, Your Lordship, on 5/3/2026, Your Lordship, for two petitioners, Your Lordship. But in that time, my lord, I was arrested on another case, Your Lordship. That is the forwarding report, Your Lordship. Kindly come on page number 10, Your Lordship. So I was arrested.
10 of your IA.
No, my lord.
Page 10 of your IA.
Yes, page 10 of my
I.
Yes, my lord. I was arrested on 2/3/2026, Your Lordship. But my lord, my interim was given by this honorable court on 5/3/2026, Your Lordship. The party was also not informed me, Your Lordship, so I could not cooperate.
He got arrested in another case.
Yes, my lord.
How many petitions were there?
There are two petitioners, and another is, Your Lordship, Sahidur Rahman. He was out of station, Your Lordship. Kindly come on my IA, page number 4. This is my.
Yes, Mr.
Any condition may be given, Your Lordship. I will definitely cooperate.
Otherwise, the CD was called on on Lordship 34/2026.
When?
30.
30 April.
He may be given time and CD may be called again.
Yes, madam.
You are Mr.
I am S. Islamic.
I heard Mr. S. Islamic counsel for the petition. Mr. K.K. Das in petition. Being on behalf of state response. This interlocutory application has been filed in connection with anticipatory bail application 439 of 26, praying for extension of time or their appearance before the eye. Most of it is submitted that provide order detail. Which was the order?
5/3.
Your bail was granted on
5/3/2026.
2026.
7 page number.
The petitioners were granted interim BRS bail with a direction to appear before the IO within 7 days from the date of order. But the petitioner number 1 could not appear before the IO as he was arrested in connection with another case. And petitioner number 2 was also outside the outside the station, and he was not informed by his family members. However, both the petitioners are ready and willing to appear before the IO and to cooperate in the investigation. Next para, Mr. Das declared additional people also raised no objection and submitted that chance may be given to them for their appearance before the IO. In view of this, the present interlocutory application is allowed, directing both the petitioners to appear before the IO after within 7 days from the date of order and to cooperate in the investigation business. Further, as with the above observation, the I stands disposed of. Aro AB to click. So 34 has put up for price. Put up to now. তাতে লিখি দিওঁ নেকি আয়টোতে লিখি দিয়ক নহ'লে আয়টোত লিখি দিয়ক the IO is also hereby directed to send the updated case diary on or for next date of listing, that is on 30/04/2025, incorporating the, no, including the statement made by the petitioners, if any. With the above observation, the ayes test. Okay.
Highly appreciate.